Good afternoon and welcome. This is a regular meeting of the Sunshine Ordinance Task Force called for Tuesday, July 28th, 2009 at 4 p.m. and beginning at 4:08 p.m. May we have the roll call, please?
Yes, Mr. Chair. Member Craven Green. Member Craven Green, excused. Member Nee.
Here.
Member Nee present. Member Cawthon. Here. Member Cawthon present. Member Washburn. Member Washburn absent. Member Caneva.
Here.
Member Caneva present. Member Johnson. Member Johnson excused. Member Chu. Member Chu absent. Member Chan.
Present.
Member Chan present. Member Goldman.
Present.
Member Goldman present. Member Williams.
Present.
Member Williams present. Mr. Chair, we have a quorum.
Thank you. Going to ask that you please turn off at least the ringers on any cell phones in the house. Any changes to today's agenda? Okay, we will have one change. Item number 2 is going to be continued because former member Allison is away and cannot attend today's meeting. Okay. Mr. Clerk, could you call item 1, please?
Item number 1 is the approval of minutes of June 23rd, 2009.
Members, I just have some typographical type items. I already given to Chris. I don't think we need to go over them here.
Okay. Anyone else? Is there public comment on the minutes?
Good afternoon, Peter Warfield, Library Users Association. I just didn't hear what was just said. I'd appreciate if the mics be on or if it be repeated. And I just wanted to say that I appreciate what seems to be a fuller set of minutes than at other times in the past. And I hope that the contents, which I have not had a chance to review, do justice to the lengthiness of them, again, which I appreciate and I think is a public service. Thank you.
Thank you. Is there further public comment on the minutes? Okay, public comment is closed. In response, Mr. Warfield, what was said before was that there are some typographical errors in the minutes, and they will be sent to the clerk for correction. Okay, is there a motion? Okay, moved and seconded. Member Cawthon, Member Williams. Roll call, please.
On the motion, Member Craven Green. Member Craven Green excused. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn. Member Washburn absent. Member Caneva.
Aye.
Member Caneva, aye. Member Johnson. Member Johnson excused. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
Aye.
Member Williams, aye. Member Chu. Member Chu absent. Member Nee.
Aye.
Member Nee, aye. Mr. Chair, we have 6 ayes.
Thank you. And let the record show that we have been joined by Member Washburn. Could you call the item number 3, please?
Item number 3 is hearing on the complaint filed by Hannah Leung and Lydia Fong against the Department of Human Services for allegedly withholding information.
Is the complainant here? Okay. Is the respondent here?
Yes.
Okay. Please approach the microphone, and you have 5 minutes.
Thank you, Commissioners. My name is Hannah Leung. I would like to at least right now refresh a memory, and we spoke of this event last time when we were here, and Mr. Curto was supposed to be here when we attended the jurisdictional meeting. The merit hearing was actually confirmed, but nonetheless their office was absent, and we have continued to today, and I would like the record to reflect that we actually objected to that continuance. However, we are the applicant of a RFQ 402, which is a real estate services vendor for the Office of Public Administrator and Public Guardian. The position was dormant and well hidden from the public for many years. It took me many phone calls to uncover the position, and when I discovered that the Keynote Properties had been performing the duties for a number of years without a contract, and that's when we inquired as to why. That's when the RFQ first surfaced. We applied to the first RFQ, which is about 2 years ago. The position, after the deadline passed, it was pulled off, and they said they would revise the standard. and the revised standard came out again at the end of 2008. We again applied for that RFQ. When we were notified in March of 2009 that Keynote Properties was selected for the position. And I called Mr. Curto at that time, and he indicated that the reason for the selection was because of the budget cut, and it's easier to have the incumbent who had been servicing the position to continue rather than training new vendors. And my office is certified with the Human Rights Commission as a women-owned minority business, and I spoke with my certifying officer. The officer also called Mr. Curto to discuss the situation and basically indicating that it may be too much reliance on one participant, and at that point he added another vendor. Therefore, now we're supposed to have 2 vendors. But during this period, I also requested to view the public file, and I had no access to the public file. And I wanted to see the better understanding and the discussion ensued the applications and to see how they come to the determination. But that was denied until I filed the complaint with the Sunshine Ordinance Task Force. And shortly after I filed the complaint, we did receive the score sheets, and they are undated, and they were scribbles and with scores, but these are subjective comments that is difficult to understand and makes no sense unless you see the entire picture. So I proceeded to request and had an itemized request for all communications, including telephone memos and oral and written memos, and also routing slips. But none of those were produced, and the indication is that there's nothing else in this file except these scoring sheets. And they said that these scoring sheets they never met. It was scored individually. I don't know how they were picked up or delivered because I was not given any routing slips, any telephone messages, none of those. So I believe the file is still incomplete as produced. Mr. Curto later indicated that since the position has not been awarded, therefore the applications are not subject to production at this time. And even if I concede that the applications itself is not subject to production, I believe that there are still other documents, and I think it should be other documents in the file for production. This contract, and this morning we had a public hearing with the Finance Committee at the Commission of Aging and Adult Services. They are the commission that actually approved the award. And at the hearing, it was discovered that the estimate total size of the contract to be, and I did not know this before, to be $600,000. With the size of the contract and the way it came about and how it was handled, I certainly am alleging appearance of impropriety at this time, and I think that we are subject to additional production. Thank you.
Thank you. Is there anyone here to present facts and evidence in support of the complainant? Okay, seeing none, would the respondent please approach? Thank you for coming, sir. You have 5 minutes.
Mr. Chairman, members of the task force, Dave Curto, Director of Contracts for the Human Services Agency. I can say that I do not agree with the facts as ascertained by Ms. Leung. We have produced for her every document that she is entitled to under the Sunshine Ordinance prior to the award of the contracts. We did put out this RFP in 2007. It's an RFQ, request for qualifications. We withdrew it and we redrafted the specifications and put it out the next year. We had 4 respondents. We made awards to 2, the top 2 scoring respondents. Those awards will be made by the Adult and Aging Services Commission, possibly as early as their meeting on August 5th. We did have a Finance Committee hearing on that this morning. And after that time, she's entitled to get the respondents' applications. We have produced all of their documents for her. And when I received this complaint that is date stamped by the board on July 16th, I was a little curious because she made the actual request of documents on July 21st, 5 days later. So this one, I put a phone call into Ms. Leung on Monday and asked if she could clarify this request so I could get her the documents. The request is for the first RFQ, number 363, that was issued in October of 2007, and it was withdrawn in December of 2007. So I'm perfectly willing to give her what documents are in that file, but there really isn't much there because we withdrew it and rewrote it. So that's really all there is to say on it. The jurisdiction for awarding the contracts and the appeal, she filed an appeal, which was allowable. The appeal was ruled on and denied. And now the contracts are before the appropriate commission for approval.
Thank you. Is there anybody here to present facts and evidence in support of the respondent? Okay, seeing none. Committee? Okay. Ms. Leung, could you approach the microphone, please? Just for our benefit here, you asked for copies of the applications, the responses to the request for proposal. Is that correct?
I requested, that's one of the items, but
Okay.
I requested a whole host of items.
Okay, and of those, besides the responses to the responses, besides the responses, which you have not received, what other documents have you requested? I just want to clarify. What other documents have you requested that have not been provided?
I actually do have a tabulated table of all the correspondence between myself and the office. And to clarify, we have filed 2 complaints under the Sunshine Task Force. The first one was for the RFQ for the current position that after they have reopened. But I have also requested the applications received in the prior RFQ that had been pulled off, because that RFQ, I know that we submitted an application as well as the incumbent submitted an application. Now, whether there's additional one, I do not know. But at most, at that time, was 2 to 3 applications it was submitted, and then it was withdrawn. And I think I would like to see the entire file of that RFQ when it was first opened.
Excuse me, that's not before this board, this task force this afternoon. That is another complaint regarding that. There shouldn't be any mix-up. That should be heard at the next meeting. We're only dealing with the second request for qualifications in that process.
Thank you, Mr. Laurenti. That's very helpful. Okay.
Okay, I have all notes and score entries. Well, actually, I have 11 items.
Okay, this is on the second RFQ, right?
This is on the second RFQ,
Okay.
the current one that we are on.
Thank you.
Basically, all notes and score entries by the selection committee regarding the proposal submitted by our company. We requested the proposal submitted by the other applicants, the Keynotes property, and the item just kind of named all the other applicants. Then we also requested the names of all the readers. That was eventually disclosed after further request. And I had also added another request, was all the correspondence and communications between applicants of RFQ 402 and the Public Administrator's Office, including but not limited to letters, memorandum, electronic mail, facsimiles, and telephone messages.
Okay, thank you.
Thank you.
Mr. Chairman.
Member Neber.
Ms. Leung.
Yes.
So just for my clarification, so from the documentation that I've had, I've looked over it a couple times. On April 21st, am I correct in thinking that you got the score sheets from Mr. Curto and the idea of the minimum qualifications? Is that correct?
No. In May. It was in May that we received the score sheets
Okay.
through electronic.
Okay. So, be that man, you after the request, you got the score sheets. You said you had to make an additional request for those score sheets to get them, or did?
Well, I
response?
had been requesting ever since March,
Okay.
when we first received our notice, when we were notified by a letter on March 7th that it was awarded to Keynote Properties.
Okay, thank you. Mr. Curto, ask a question. So I saw you look when I asked this question. So this letter that we have of April 21st, which is on page 43 of our documents, that has the score sheets. Was that sent after the request, or was that in addition to the original? Or is this your recollection? Is this the scoring sheet that you sent to her in regards to request?
Well, I don't have the document in front of me.
It
but
is dated April 21st, and it has the evaluation selection criteria, and on the back, it is a scoring analysis for RFQ number 402.
It's one of several letters that I sent to her. Yes, this does have the selection criteria, and
Okay.
we provided her with a scoring sheet. And subsequent to this request, we provided her with the actual notes from the three
Okay.
reviewers.
Okay, thank you very much.
Thank you.
Mr. Laurenti, do you have
Yes.
a comment?
Yes, there was a question at the last meeting regarding this case, and that was the question of whether Mr. Curto believes that 67.24E1, which deals with production of materials on a request for proposal, RFP, is applicable to his situation, which is an RFQ, which is a request for qualifications. There is a specific standard, and that is spelled out under 67.24E1, which I have listed in page 24 of this packet, but it says 25, it's 24. And I guess the question is everyone in agreement that this section is applicable to the facts of this case? That wasn't clear from the last meeting.
I think the department would stipulate that it is applicable. It doesn't make a difference to us.
Thank you. Okay.
I would tend to agree with that. I think that the RFP is.
I
Right.
think they're analogous.
Yeah, I do too. I especially marked that when I was reading it, and I agree.
From looking, excuse me, but from looking through this, I've looked over this quite a few times. We've looked at this, we've read through it, and I just don't see what Ms. Leung is looking for that's not here besides the actual applications, which cannot be released. So I'm leaning to find no violation.
Is that a motion?
I move.
Is there a second?
Second.
Okay, moved and seconded. Is there public discussion? Well, before we, is there public discussion? Okay. The respondent, if you wish, you have 3 minutes to make any closing or rebuttal statements.
I have no statement to make, but I am willing to go forward on the second complaint that was filed on July 16th if it so pleases this body.
I don't believe that would be appropriate at this time. That has to be calendared for our next meeting.
I understand.
Okay. Ms. Leung, do you have any closing or rebuttal statements you wish to make?
And my question would be, in finding as there's no violation, is that then a determination that all that he had produced would be the entire file of everything that he has to produce?
That would be a fair interpretation. However, once the contract is actually awarded, then the other records that you have requested will become public and will become disclosable.
All right. But just for the record, this is all that is in this RFQ. And I just cannot believe that this an entire file when it is a $600,000 contract. But if that's what the commission believes, then we will just wait for the...
Well, the size of the RFQ is something that's beyond our scope.
Chairman Nee, may I respond just quickly?
Member Knebber.
The problem that I have with this is that you're not proving to me that there is something else. You think there's something else, you have an idea, but I don't see any proof that there is something else that you need that he hasn't given you. And unfortunately, that's all that we are allowed to decide upon.
Sir, when I requested the entire file, I think even letters to myself should have been produced. And if there's letter to me, I would imagine there are letters to others. I don't believe there's absolutely no telephone calls, no telephone messages. These files and application were magically transferred to these reviewer and readers without routing slips, without telephone messages. They are found every time at their desk, pick up the phone and answer Mr. Curtle's call. And they would walk over and pick up these applications. I don't believe that. But if you chose to believe it, then we have to abide by it. But I do not believe it. And I think at the very least, when I say production of an entire file, doesn't even matter if I have it in my possession. He is supposed to produce the entire file. And my letters that I have received is part of the file. And if I'm the only person receiving letters, and I don't think so.
Okay, thank you very much.
Thank you. We have a motion and a second. Mr. Clerk, roll call, please.
On the motion to find no violation, Member Craven Green. Member Craven Green excused. Member Cawthon.
Microphone.
Microphone.
Aye.
Member Cawthon, aye. Member Washburn.
No.
Member Washburn, no. Member Caneva.
Aye.
Member Caneva, aye. Member Johnson excused. Member Chan.
No.
Member Chan, no. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, no. Member Chu. Member Chu absent. Member Nee.
Aye.
Member Nee, aye.
Mr. Clerk, I'd like to change my vote. Can I do that?
Right. Mr. Laurenti.
I'd like to change my yes to a no.
Yes, possible. Yeah. Yes, you can do that.
Member Cawthon is no.
We don't have a
We do not have a
Motion fails.
motion fails.
Motion fails.
Yes.
Okay, the motion has failed. Is there a motion to find violation?
I so move. I was convinced by the complainant that it's reasonable to assume that there was more in the file than what was produced to her.
Is there a second?
Second it.
Moved and seconded. I don't think any further discussion is necessary. Roll call, please.
On the motion to find violation, Member Craven Green. Member Craven Green excused. Member Cawthon.
No. Yes.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Caneva.
No.
Member Caneva, no. Member Johnson excused. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
No.
Member Goldman, no. Member Williams. Member Williams, aye. Member Chu absent. Member Nee.
No.
Fails.
The motion fails. I believe. What was the count?
Same thing.
Same count.
4%.
We had 4 ayes, 3 noes, I believe.
Yes.
Okay. The motion fails.
No further action.
There is no further action at this time. Thank you both for. Thank you. The matter is concluded. Thank you both for attending. Mr. Clerk, could you read the next item, please?
Item number 4 is the determination of jurisdiction on complaint filed by Charles Spitz against the Department of Human Services for alleged failure to respond in a timely manner.
Members, I move that we find jurisdiction on this item.
I second.
Moved and seconded. Is there public discussion on jurisdiction of this matter? Only on jurisdiction, not the merits. Seeing none, is there discussion by the committee? Okay, roll call, please.
On jurisdiction, Member Craven Green. Member Craven Green excused. Member Cawthon.
Yes.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Caneva.
Aye.
Member Caneva, aye. Member Johnson excused. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
Aye.
Member Williams, aye. Member Chu absent. Member Nee.
Aye.
Mr. Chair, we have 7 ayes.
Okay. We move now to the actual merits of the case. Is the complainant here? Mr. Pitts? Okay, and is the respondent here? Okay, Mr. Pitts. Thank you for coming, sir. You have 5 minutes.
I sent my letter out, and I think it was between a week or 2 or 3 days before I even got a response back, and that is part of the complaint. I think the other half of the complaint is that I got part of the information that I was requesting and not all of it. The other part about it is they have this council, and it seems they rarely meet. When you go to their website, all you really get is a picture of some lady smiling at you, and you can get a PDF of some document they wrote probably like 4 or 5 years ago, and that's for the most part that was on the website when you received when you looked near the time when I submitted that complaint. So it was like you have this council that rarely meets, no information about it, and I'm just trying to figure out who do I talk to, where do I go to make things within our society better. And all the other avenues I've tried just were not working. And when I'm asked, let's start here. See, one of the requests that I asked for was 10 documents / emails regarding why the last meeting was canceled. And I didn't get that information. And I asked for it, I didn't get it. And then the other thing, too, that I asked for was the bylaws of this council. And I didn't get that either. So, it'd be good if I could get that information. Although the information received was definitely late, I did receive that. I believe she also might have sent you a document saying that the information I received was late as well. So.
Okay, is there anybody here to present facts and evidence in support of the complainant? Seeing none, would the respondent please approach? Thank you for coming. You have 5 minutes.
Thank you. My name is Pamela Tebow. I'm from the Human Services Agency. There are a couple different issues with Charles's complaint. One is he submitted a complaint to one of our staff, Allison Schlageter, in our Housing and Homeless Division. Not a complaint, I'm sorry, an immediate disclosure request directly to her, but addressed it on the top to our director, Trent Rohr. And I'm terribly sorry we were late because Allison from our staff believed I had a copy and was working on it. I didn't have a copy. So I got the copy a little bit later. And it was our misunderstanding. I know sometimes Charles knows that I actually process the public records requests, and sometimes he'll send them to Dave Curto, and Dave automatically sends them to me. And Allison from our Housing and Homeless staff didn't realize that. So we were in fact late, and I apologize. And I've since straightened that out. The next thing is, though, on the issues or the items that Charles asked for. He had asked for the agenda and minutes of the last 10-year plan council, so I gave him that. He asked for a copy of the bylaws. We don't have a copy of the bylaws, and I'm not quite sure they exist. And he also asked for, he writes, I am requesting the first 10 emails and any other documents regarding the May meeting regarding of the 10-year Plan Implementation Council. And I asked him to clarify that. So I didn't respond to that because I never got clarification on that. And then he also asked for the council's chairperson, Angela Aliotto's contact information. And there's one of our staff who volunteers to help schedule the meetings. She is the actual contact for Ms. Aliotto because she does not have a city address. And I had checked actually with the task force to find out what information I should give him about Angela Aliotto. And he said that, it was Frank Darby, said it was fine to produce just, a contact for him to reach Angela. The other thing is, we're not part of the 10-year plan council to end homelessness. The Human Service Agency does not have any members on that council. I believe it was a council created by Mayor Newsom, and there's nobody on our staff that's one of the council members. So I know that if we have a document, like we had the minutes and, an agenda, that if we have them, of course, we turn them over. But as far as when the council meets and whatever, their website, we have nothing to do with that. So I think that responds to his complaint. Thank you.
Thank you. Is there anybody here to present facts and evidence in support of the respondent? Seeing none, committee? Member Cawthon and Member Williams?
I'd like to ask Ms. Thibault, please. I was in the back of the room, so I may have missed it when you talked about your response to the immediate disclosure request. Mm-hmm. Did you mention that you did, you were not timely on that?
Oh, absolutely.
Okay.
And it was just because I never received it, that it was another staff member who assumed I also received it. So I'm terribly sorry.
I understand.
That's our communication.
So do you have a procedure in place so that when an immediate disclosure request comes in, whomever on your staff gets it will send it to you? Mm-hmm. Yes. The reason I mention this is that I chair our education committee, and we find that a lot of departments really don't know their responsibilities under the ordinance, and we want to make sure that they have safeguards in place to assure that the rights of the public are protected.
No, you're absolutely right. And several years ago, we did type up an all-staff memo and addressed it. Had a meeting with our senior staff on it, but it's probably time that we send the memo out to all of our staff again to remind them, because Allison, for one, is a new staff member and probably didn't read that. But you're right, we probably should do that.
And I guess my third question is that I didn't think it was so difficult. The first 10 emails, I could understand what he wanted, so I was not quite clear on your reasoning there.
Oh, I don't know what that means. Can you tell me? I'm requesting...
Well,
I'm sorry, I'm requesting the first 10 emails and any other documents, possibly because I don't have anything to do with the task force.
If it had been me, I'd have given him what I had.
Yeah, I don't have anything.
Yeah,
so I have to rely on a staff person that would occasionally go to the meeting.
Okay, well, I just wanted to make the comments. I mean, you certainly seem, dedicated to performing your job appropriately, and then these are things I think that need to be possibly looked at. So that's all I've got.
Okay, well, I'm terribly sorry. I don't know what that is. And I asked for clarification, and he never responded, so I don't know what he wants.
Thank you.
Member Williams?
I really have a concern, since this is one of the, council that Mayor Newsom had put together, that there would not be a representative or someone from his office there if he had set forth a council, and especially knowing Angela Aliotto, it would be surprising to know that you guys wouldn't have the bylaws, because I know she is proficient in keeping records.
Right.
And while you guys wouldn't be working together, being human services and social services and the homelessness program, how important it is in this city, that you wouldn't be collaborating and connected, and that your office wouldn't have these files, especially the bylaws and the meetings. Those should be readily available through your office too, since it was created by the mayor. And it just doesn't seem feasible to me that the mayor would just throw out and say, you guys form a committee or a council, and he doesn't have a representative there. It looked like he would want some feedback at some time. Who gives him feedback?
That's between the mayor and Angela Alioto. I'm terribly sorry, I don't know. But I know we are not on the council. So
Well-
my department has no representative on the council. So I don't know. That's something I'm sorry.
So
I can't
you're
answer.
you're telling me under this program, this the only thing the information goes between Angela Alioto and the mayor on the homeless council.
I have no idea because I'm not on my department has no one on the council, so I don't know. We're not council members, so I don't know.
Well, I find that very disturbing that we don't know what programs and what goes on, especially with taxpayers' dollars. And most so not only with the taxpayer dollars, with the human beings being homeless, that we don't have those procedures.
We have lots of procedures and programs. This is a separate council, and I'm so sorry we're not on it, and there's nothing I can say. And that doesn't mean that the mayor hasn't appointed people. There are people on it, but it's just not us. And I'm really sorry. I'm not the one, and I don't answer for the mayor. So I'm terribly sorry.
Well, was there somewhere that you could have referred him to find out that information?
If I can answer, we did refer him to the 10-year council. The mayor does have an appointed person, Mr. Darius Kahan, who sits on the council, and he reports to the mayor along with Ms. Alioto. We don't, like I said, we're not at those meetings. Whether they have established bylaws or not, we don't know. We did refer Mr. Pitt's request to Mr. Kahan. And we did not get a response from that, so I don't know what has happened there. But we simply don't have the records that we can produce. So to expect us to go find the records when another council is in charge of it is going a little too far.
Okay, I can understand that, Mr. Kuto. Mr. Pitts, when you were referred to this person, did you contact him in any shape, form, or fashion?
I would like to see that they even sent me. I don't know if I got anything about going to Darien Kirsch or not. I mean, I'd like to see it if I did.
What do you mean you would like to see it? You'd like to see it in writing, or you don't remember that they told you?
Possibly both. I don't know if I remember, but I don't know if they even sent me to Darien Kirsch. But see, to me, my thing about it is just like they keep talking about they don't have somebody on staff. I mean, they don't have a member on that council, but they have a staff member who works with that council. So they have Alice Schlesinger, however you pronounce her last name. So, they do have access. They do have access to those records. And if you do understand that a staff member they have on some levels they have more privileges than a regular council member because they can, they're writing out agendas, they're taking minutes, they're just doing other stuff that a regular council member just wouldn't do. So, I mean, for them to tell you that they wouldn't have access to the bylaws.
Not cutting you short, but have you ever been to one of these council meetings?
I think there's several problems with that.
No, I just want to know, have you ever been to one?
They so rarely meet, I can never really get to one. I think I got information for one, and I just missed it. But they meet like maybe 2 or 3 times a year.
So you don't know when they meet, so you don't know when you could get there.
Because see, the other thing too about it is that when you go to their website, they have like 10 different They have like 4 or 5 different platforms where they meet, like the first Tuesday, the last Friday. I went to one of those, like it said on the website, and it was pretty much just a little bit bigger than a broom closet, and the room was empty.
Did you see anybody taking any minutes or anything?
The room was empty. I mean, I went there, it was empty. It was kind of like you have a website that hasn't been updated in like 4 or 5 years. So all the information on this website is obsolete. I mean, until I started complaining.
I think we're straying a little bit here.
Yes.
I'd like to get back on. I'd like to get back on target here, Mr. Chan, Member Chan.
Yeah, I'm just kind of like looking at this paper. Right, it looks really official. It's a city paper, and it shows the Sunshine Know Your Rights in the back, right? With this organization, well, I got just one question. Who appoints these members?
It's our understanding they're appointed by the mayor.
So it was appointed by the mayor. And I'm kind of puzzled. How come Mr.
Darius Cahan
is not in this paper? Saying that.
I can't answer that question, but what I will volunteer to do is to contact him and try and get the information that Mr. Pitts is seeking.
And as well organized and look really official by the public's eye, right? They should have a bylaw, and I'm just really troubled on that.
But that is something you have to ask the council, not me, not our department.
Microphone, please.
I'm terribly sorry. That is something you have to check with the council. We do have one staff member who started volunteering, taking minutes, and trying. I don't know if she takes minutes, actually, trying to coordinate some meetings. She recently came on board from another staff person doing this. So she gave us what she had, and she's trying to collect whatever documents. But this is the 10-year plan to end homelessness council is not a human services agency council. And keep in mind that this council was created several years ago, and perhaps the reason that they don't have regular meetings any longer is because their report is finished and published. So that could be an issue why they don't find the need to meet monthly.
The question is, then why are you here and not Mr. Dar?
They complained against me. The complaint is against me. So I am here to respond on behalf of the Human Service Agency on what information that we provided to him, to Charles. So that's it. And to come and tell you that the 10-year plan to end homelessness is not part of the Human Services Agency. So there are two different issues. It doesn't matter whatever we have in our files. If we have them, we turn it over, whether we're on the council or not. And that is our responsibility to turn over what we had. So I don't even know Dar's involved.
Can I give you a little bit of background on it? The 10-year plan was mandated by HUD to continue our HUD funding to end homelessness. It's mandated that every jurisdiction have a long-term plan. So the council was put together to assemble our 10-year plan, headed by Angela Aliotto. The plan was completed, I believe, I read it 2.5, 3 years ago. So the plan was completed, so I'm not sure there's any need for this council to continue to meet regularly. Whether the council was formed as a task force that had formal bylaws, I'm not sure. But I think that's really the background on it. So if Mr. Pitts wants information on that, we can ask the council. But I think the reason they're not keeping regular meetings is their task has been completed. They have completed the 10-year plan.
Thank you. Member Washburn?
Actually, my question's been covered.
Okay. Member Knebber?
All right. I think we've talked about this for a lot longer than we needed to. To me, this boils down to this is not the correct agency to be asking this question to. They were asked here. So I would feel that we should find no violation, and when the appropriate time comes, I will make that motion.
Okay, let's. I just have a couple of questions. Ms. Tebow?
Yes.
Regarding what is the actual repository of information and records for the council? Do they have their own? Is it its own entity?
It's its own entity, from what I understand.
Okay.
Actually, it would be better to have somebody from the mayor's office respond to the creation and implementation.
Okay, and regarding the contact information for Angela Aliotto, you said you contacted Mr. Darby about this? Mm-hmm. Okay. Did you contact Mr. Laurenti, who was our deputy city council, or did you contact counsel of your own?
I'm not quite sure, because Mr. Darby, he's very thorough.
Yes,
I remember
he is.
Talking to him about this.
Yes,
and
he
I
is.
Didn't
yes,
feel
yes.
the need
But
to
just going forward in the future, it might questions like that might be best posed to council. When Angela Aliotto has email communication, for instance, with the city, with others on the council, with the council office, council staff, that is, that is official business of the council. Does she have? Does she do that from a personal email address? Does she do that? How does she do that?
I'm not sure.
Okay. Because I am really not sure that information should be kept confidential. If she is communicating with the council on official city business, if it's from her own email address, then that becomes public record. That's to the best of my knowledge. Okay. Whether you have that information, I don't know. Who was the lady to whom you referred his question?
Allison? You mean Allison from our Housing and Homeless Division who has coordinated?
The person whose name you gave to Mr. Pitts as the...
Allison Schlegeter.
Okay. Yes. If you don't have if you don't have that information about Ms. Aliotto, then then you don't, and perhaps you cannot be held accountable on that score. But if Mr. Pitts were to approach Ms. Schlegeter on it, I'm not sure she would have I think she might be on very tenuous legal grounds if she withheld. I have nothing further. Is there public comment on this matter?
Good evening, Thomas Pecorello. I'm looking at a copy of an email from respondent to the complainant, and hopefully this email's in your file. It says that complainant requested the documents from the staff person of the 10-year homeless council, Allison Schlegler. The email from respondent says that respondent is the custodian of the records, not Allison. So for all other records from the 10-year council, they should be forwarded to Pamela Tebow. The 10-year council does meet. They're required to meet to get federal funding. They get McKinney-Vendo funds every year, $20 million a year. They're required to meet. Complainant was requesting the bylaws so that he could prove they're violating their bylaws by not having meetings. So the response by Ms. Tebow, the respondent, that she doesn't know if there are bylaws is a breach of her duty, since she represented to the complainant that she's the custodian of records for the 10-year council. Thank you.
Is there further public comment? Okay, seeing none. At this time, the respondent will have 3 minutes to make any closing statements or rebuttal.
Again, I am not the custodian of records. I cannot have a copy of every single document that our 17 to 1800 staff have. When we get a public records request, it is supposed to be sent directly to me, and then I work with appropriate staff to respond. I was told by Allison that there are no bylaws. I don't know, though. I personally have no knowledge of bylaws or not bylaws, but I wouldn't be the person to answer the bylaw question. That would be the council, not me. The Human Services Agency is not part of the 10-year plan council. So I'm sorry. If I knew I was supposed to find out all about this council, then perhaps I could have brought somebody here that could answer these questions. But it's not part of my job. I do not keep a Xerox copy of every single document that our department has. That's impossible. And I don't for, Allison gave it to me. Allison never gave me the public records request. I ended up getting it. I worked with her to respond with what I had, and it's only what our department had, just as as a department who happens to have some documents from the council. They happen to have, agenda and minutes. That's it. So I don't know that my department, and I don't understand why my department would be required to have all this stuff. I'm terribly sorry. The council was made up of many different people. We just weren't one of them. And it was like an advisory council. I don't know exactly what they were doing. They came out with a report. I don't think that they have to meet every month or whatever they originally did prior. But I'm not prior to creating the report. I'm sorry, I'm not the person. My department is not the department. But I am responsible to turn over to Charles whatever documents we have in our files that pertain to his question, whether I'm part of that council or not. So I'm really, really sorry. We don't have in our files bylaws. They may exist. We don't have them. I made some phone calls, called around. I asked some other staff. I asked, other people that had occasionally gone to the meetings. They were not aware of bylaws. It's not like I just dropped it. I don't have it. That's it. I mean, I did go out and try to get answers. I did call Frank Darby and I asked him, what kind of information when they want Angela Alioto's personal contact information? Am I supposed to try to find that and give that to him, or do I just give them, a contact person that can relay information to her? So I did go above and beyond and try to get the documents he wanted. I asked him to clarify this 10 email thing. Sorry, don't know what it is. And we can't ask if we're not sure. And I'm sorry, I'm not sure. So my job as not the custodian of records, my job as the person who handles public records requests, is to get the request, work with staff, and provide a response.
Thank you, Ms. Tebow. Mr. Pitts, if you wish, you have 3 minutes for conclusion and rebuttal.
I don't understand how to clarify any. To me, open up a dictionary, figure out what the word any means, and then go figure out how to apply that. I think the other thing, too, is I don't see, the 10-year implementation council became part of their responsibility when they have one of their staff, working with it, running it, whatever you want to call it. There's they do own some liability because they have a staff member there doing the paperwork, minute taking, whatever you want to call it. Now, my other problem is all the times I've been here, I've run all of my 6725-A's primarily the same. I go up to David Curtle's office. I have 2 copies. I stamp both of them. I put one on David Curtle's desk, and I leave. There's no, they're trying to turn Alice Schlesinger, however you pronounce her name, into a scapegoat. When you look at the document, it has a stamp from the city and county of San Francisco on it, just like all the other ones I had. When I meet her at another committee meeting, the 10-year, I meet her at another meeting, and we go into a room, and she doesn't have the stamp. She doesn't have the stamp for that there. She don't carry a city and county of San Francisco stamping machine to stamp documents. This document was on David Curtle's desk. I don't know what David Curtle did with it, how it got late, whatever they did with it, but you're turning her into a scapegoat. I wish I had more to say.
Thank you. The matter is back with the committee. Is there a motion?
Well, I would
Member
move.
Coughlin?
I would move to find a violation for an untimely response. And regarding the others, I in my personal opinion, the 10 emails, you can count to 10 and send the email. So I would find untimely response and also failure to produce. That would be my motion.
Is there a second?
Second.
Moved and seconded. Discussion. Member Knever?
I would agree with the first part, but not with the second. I agree that they by their own mission, a timeliness issue, but I still don't think it's the responding agency. So about the emails, I would have to disagree. So I'd have to vote no on that motion.
I have the same problem. I wish there were two separate motions. I can't vote on that motion at all because I agree with the first and not the second.
Okay, is there a request to separate?
I so request.
I second that.
Okay. Then we will separate the motions first on the immediate response question. Roll call, please.
On the first motion, Member Craven Green excused. Member Cawthon.
So the question is on violation.
On violation.
On violation only of immediate disclosure response.
Okay, aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson. Member Johnson excused. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, aye. Member Chu. Member Chu absent. Member Nee.
Aye.
Mr. Chair, we have 7 ayes. On the second motion, Member Craven Green excused. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
No.
Member Washburn, no. Member Knebber.
No.
Member Knebber, no. Member Johnson excused. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
No.
Member Goldman, no. Member Williams. Member Williams, aye. Member Chu. Member Chu absent. Member Nee.
No.
Member Nee, no. Mr. Chair, we have 4 noes and 3 ayes.
Okay. I don't think an order of determination is necessary for issuance. The respondent has admitted on the immediate disclosure, and we have not heard any previous complaints, so there is no evidence that the lack of timeliness on response is any sort of deliberate pattern. And I believe that concludes this matter. Thank you both for attending. At this time, we have public comment on items not on today's agenda and falling within the jurisdiction of the task force.
Thank you very much. You'll notice that later in this agenda is an item concerning a complaint by Sue Coffin. And Sue Coffin came to a Library Commission meeting subsequent to that and said that she felt very traumatized. And it seems to me that's of the essence. People in this area refer to depriving people of access to reason as a psychic assault. And the reason they use that term is that it's only analogous in terms of the effect on human beings and the effect on human society to violence. It's a separation from reason, and it has all of those traumatic aspects that flow from it. And of course, the perpetrators of this know full well that they're committing a psychic assault. That's why when we went to the Library Commission at a subsequent meeting to complain, they laughed in our faces while we were talking. They know full well that it's psychic assault. The whole idea is that when the whole thing is over with, they will turn to you, look you straight in the eye, and say, well, at least we're civilized. Well, that kind of terminology is a completion of the psychic assault. I beg your pardon, but civilized and civility means living by a set of rules that apply to everyone and accepting people's human dignity irrespective of their particular opinion and their right to express it. So it doesn't matter, the peculiarities of the technical violation or the lack of technical violation. They'll turn around and say, well, it's just a technical violation. We don't do that to nice people. But of course, if you decide who's a nice person, who's civilized, by treating people in a rational way in some instances, and then deciding that you're going to treat other people that you don't like the way they treated Sue Coffin in that incident, of course, that gives them a power in a democracy to, in fact, destroy democracy. And that's why we have institutions that are publicly funded. That's why we have institutions that are open. That's why we have all these traditions connected to democracy that we call sunshine, exactly so that people can't pay their money to treat people that way, and to make sure that those people who do give the money don't get treated that way. It's a creation of a barrier in society that should not be allowed to exist. Thank you very much.
Thank you. Before we proceed further, the chair will advise that public comment is limited to 3 minutes, and this is being applied uniformly. Sir, please proceed.
Public comment?
Yes.
Yes. Commissioners, good afternoon. My name is Emil Lawrence. I've spoken before the Board of Supervisors, the Municipal Transportation Authority, and the International Airport Commission. Over the past 3 months, I've attempted to get the Municipal Transportation Authority to be more transparent and open on hearings related to the Taxi Commission and hearings related to their own affairs. And now, since I think as of the last several weeks, they've canceled all meetings for public access between now and December 31st. They've been denying public access on any Taxi Commission hearings by submitting documents and not putting one of them in any news leaf such as that during the meetings. They've basically run over the San Francisco Taxi Commission, which had public hearings twice a month that went on for 3 to 5 hours at given times on issues related to the taxi industry. Now that has been totally denied public access, even during the MTA meetings when they had them. And now, based on the big calamity taking place between Gavin Newsom, the mayor, trying to attempt to sell taxi medallions by taking away a property right from medallion holders, 1 and 2 people on the list to obtain a medallion has been on it between 10 and 20 years, that they've killed or canceled all hearings related to that. There are no hearings whatsoever now before the MTA between now and the rest of the year. I've submitted 4 to 5 letters to the city attorney, to the Ethics Commission, asking for an investigation of this, and nothing so far has taken place. I don't know what the procedures are in terms of bringing it before the Ethics Commission, but I'm not against going down to Superior Court and getting a court order to get him to start doing something or comply with the law based on public interest. I know the Sunshine Ordinance is of value to the city and county. The mere fact that the public can come up and speak and ask questions related to issues that are non-transparent, such as budgets, and I've done that as well, but all of that now has come to a halt because the MTA has canceled all the meetings for the rest of the year in relation to not just taxi meetings, but the controversy between the medallions and their own budget. Nathaniel Ford, which I brought up before the Board of Supervisors and the MTA, does not have the credentials to be the MTA czar. He doesn't have a college diploma even approved in the state of California, let alone New York, and he took Atlanta into bankruptcy. He's taken us into bankruptcy, and he refuses to comment on any of this. He left Atlanta under the indictment, not an indictment, but accused of embezzlement for $150,000, settlement of a $1.1 million sexual harassment suit, and no one wants to discuss any of this. At the same time now, we are in bankruptcy. The MTA is $130 million in the hole. No one wants to discuss the fact that revenues have dropped almost 40%. At the same time, expenses for the MTA have gone up 9% and are higher next year than they are this year because salaries refuse to go down. And all of these issues, I'm getting stares in the face, and there's no comment even out of the city attorney's office on that. So I'm asking you, commissioners, what is my procedure to bring that before the Ethics Commission or to the Sunshine Commission right here to discuss exactly what is going on and what our rights are versus what they're doing?
Thank you.
Thank you.
Is there further public comment on non-agenda items?
Yes, good afternoon, members of the board, members of the audience. My name is Lieutenant Daniel Mahoney. I'm the head of the legal division for San Francisco Police Department. This item is not on the agenda today. It addresses a past complaint that we're addressing, our Index of Records project that was documented in Task Force Complaints number 08056 and subsequent commission complaint of 09008. This is just a quick update. The last time I was here, I gave you a verbal time limit that I was going to put myself out for August 1 to have the index of records completed. I'm here to report that the police department has completed it on July 18. I forwarded it that day to the city attorney's office. I had hoped the city attorney would get it back to me so that I'd be standing here telling you it's on the website. However, I did speak to city attorney yesterday, and they are telling me that it's going to be at least another week before they get back to me with any proposed changes to some time frames for some of the documents. So I know this is on agenda for August 25th, I believe it is. I fully expect to be standing here the 25th telling you that it's on the website and the project is completed.
Thank you very much for the update. Is there further public comment on non-agended items? If the second gentleman who spoke will remain, once we have all of the public comment out of the way, I will have a response to the questions you asked. No. The gentleman in the gray coat. Sir, stick around. Once all the public comment is complete, we will have an answer for your questions, a response to your questions. Please proceed.
Yes. Good afternoon, Peter Warfield, Library Users Association. I think that the first speaker made some excellent points. For those who don't know, he has a history of being on this body as chair and vice chair and knows whereof he speaks when he speaks. I'd certainly agree with a great deal, if not all of what he said. Now we come, in my view, to this body where there is some hope for the public of repairing or making, at least in part, if one can say, making people whole. I was very disappointed to hear a member of this body saying earlier during a hearing that there is a limit on what you can do, and something to the effect that's all that we can do. In fact, this body, as I've said to it a number of times in the past, has a tremendous latitude with regard to your procedures and with regard to what you do to let it be known publicly, as well as advising the supervisors specifically on what you think is necessary or relevant with regard to sunshine. Certainly in previous Sunshine Ordinance Task Force groupings in past years, you have had some very, very active members who were vigorous in trying to ferret out the truth through asking questions vigorously and fully, so that if there were ambiguities or uncertainties about the facts, that those folks present would be asked very vigorously, so that you could at least attempt to find out the truth. And to say that we can only, and then put some kind of a restriction on what you're entitled to do, I think is unfortunate and also wrong. I wish I could cite you particular examples. I think some of the older folks here will remember when there were people like the publisher of the San Francisco Bay Guardian, Bruce Brugman, who was particularly vigorous, I think, in questioning those who came before this body to try and find out the truth. So, as an example, I don't see why one couldn't ask the respondent or the complainant very pointed and particular questions about the facts, which one side or the other may not have stated, and both sides may not have stated. And I'm glad to see that Member Williams is nodding vigorously in what seems to be agreement. In any case, I think that this body has a kind of job, but it also, I think, has a higher duty to try and do justice for the public that comes before it. And I would urge you to take the broadest possible view of your role in finding out the truth and in delivering some measure of justice to the folks who come before you. Thank you.
Thank you, sir. Further public comment?
Good evening again, Thomas Piccarello. You might recall last year I filed a Sunshine Ordinance complaint against the Budget and Finance Committee for allowing only 2 minutes of public comment and then subsequently appropriating millions and millions of dollars to city agencies and nonprofits. You in your collective wisdom, found there wasn't a sunshine violation. This year, the Budget and Finance Committee allowed 1 minute of public comment. I think that that's not the intent of the Sunshine Ordinance regarding open government. So what I would urge this task force to set up a committee to discuss to what extent the public ought to be allowed to participate and comment on $6 billion a year appropriations. Thank you.
Thank you. Is there further public comment on non-agenda items? Seeing none, public comment is closed. In response to the last speaker, actually, this is the question you raised about time limits set by committees and so forth is a matter that we have been examining as we move forward with a package to amend the ordinance. So stay tuned. Regarding the second person, the question put forth by the second person who spoke, and I'm sorry, sir, I don't remember your name, but here's what I have to say. Emil Lawrence? Emil Lawrence. Thank you, sir. Mr. Lawrence, if you have specific complaints against a given entity, if you feel that the Ethics Commission is the best place to file that complaint, they have processes to do that. The Ethics Commission office is at 25 Van Ness. If you feel you have a complaint, if you feel your rights under Sunshine have been violated, you may file a complaint through our administrator in room 244 of City Hall.
I've asked for a complaint form there, and they've never given me one. They just give me the...
Sir, please approach the microphone.
Yeah,
Sir, please approach the microphone.
Come on up. Yep.
Mr. Nee, I've been in the room 244 several times. I've asked for complaints. No one seemed to have a complaint form. 1. 2, they don't even seem to have copies of the Sunshine Ordinance. They have to run them off the computer. And 3, it's no one's ever advised me that, this has been going on for a year, that I could file a complaint, an actual official complaint on a form, and bring it before this commission, because no one, when I've asked questions there for the one person who's been in the office or 2 at any given time, they just looked at me like I was stupid. Well, you're here. So I would like a complaint form, and yes, I'd like to bring it before this commission.
Okay, Mr. Rustum, can you update us on this?
I'm surprised to hear the accusation, because the front desk has all the documents that he needs and provided at any given time.
Okay. Okay, sir. Let me say this. The number for the task force administrator, the phone number, is 554-7724. We also have a website. It's sfgov.org/sunshine. And also you can send the administrator emails, sotf@sfgov.org. And
so I can get all the forms downloaded from SFGov. Okay. All the forms are on there. Okay.
Mr. Chair, we have
spoken. That answers the question. Because 244, I've been in there several times, and also I've talked to various people over the last year and a half, and a lot of people connected with the MTA and the Taxi Commission seem to be perplexed on how you file a hearing here outside of just submitting a letter and saying we're complaining and that's it.
Sir, that's between you and them. I'm talking about if you have a Sunshine complaint,
right,
file it through the administrator's office.
Okay. I got that. Thank you, sir.
Thank you.
Thank you.
And I believe we are ready now to proceed with items 6 and 7.
Item number 6 is the determination of jurisdiction on complaint filed by Sue Cawthon against the Library Commission for allegedly denied public comment.
Okay, Member Cawthon.
I'm asking to recuse myself since it's my item.
Without objection. No objection. Thank you, Member Cawthon. Member Knebber.
Just in interest of disclosure, I have been involved peripherally with the North Beach Library and with the San Francisco Main Library, but I don't think it will harm my judgment in any way. So I will not be asked to be recused.
That's fortunate because that would deprive us of a quorum if you had to recuse. Okay. But let me ask: does the complainant or the respondent have any objection to Member Knebber participating in this matter? Seeing none, let us proceed. Member Cawthon, would you?
We have jurisdiction determination.
Right.
Members, I move that we find jurisdiction on this item.
I second it.
Moved and seconded. Is there public comment on jurisdiction? Seeing none, roll call, please.
On jurisdiction, Member Craven Green. Member Craven Green excused. Member Nee.
Aye.
Member Nee, aye. Member Cawthon. Member Cawthon recused. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson. Member Johnson excused. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Aye. Member Williams, aye. Member Chu. Member Chu absent. Mr. Chair, we have 6 ayes.
Thank you. We will proceed. Is the respondent present? We know the complainant is. Is there somebody here representing the Library Commission? I believe we have some nods in the audience, so I will assume that's a yes.
I don't know.
Okay, Member Cawthon, please proceed, and you have 5 minutes.
I hate to do this after so many people have come down to speak on my behalf, but we have so few people tonight, and we have had trouble getting a quorum, so I'm going to ask for a continuance. And I'm not sure if the library is here, but I think the library should be here. And I also think all the members of the task force should look at the video and read the transcript, because this is very important. It's endemic to what we do. So I'm requesting a continuance.
Is there anybody here from the Library Commission? All right, committee. That's the that's our first item of business. Then, whether we want to continue this item.
I think if they're not here to speak for themselves, we ought to.
I am not so sure. I think absence of a respondent is not necessarily a reason to continue a matter, particularly under 67.21E. Member Knebber?
But I do believe that at the request of a complainant is an automatic continuance. So,
all right. Without objection?
Without objection.
Matter is continued. I would, Ms. Cawthon, let me ask you about the video that you were referring to. Is this something that you were going to present as part of your 5 minutes, or
right? Yeah, it's all queued up and everything. I mean, as I said, I hate to do it.
All right, let's not do it now. Then let's wait until the matter is taken up at our next meeting. It should be, if it's part of your presentation, it will be part of your 5 minutes when you present.
Okay.
Okay.
Mr. Chairman.
Will there be public comment on this?
Member Williams, could you use the microphone, please?
Was anybody from the library notified to be here?
The library was sent 2 notices. There were
2 notices.
2 reminders, yes.
You know, this is getting kind of old, that people don't show up.
Can I change my mind?
Yeah, this is really, it really is, and I'm with Mr. Warfield. We come out here and we give up our time, and we're sent these papers, but we should be able to face these people and talk to them face to face and be able to ask them pointed questions. And it still seems like they're ignoring us, and I really don't have time for it. I'm not going to leave this board like some people have gotten tired of being on this board. I'm going to stay here and stick it out for the residents of San Francisco, because they need to be heard, and these departments need to show up. And if they don't show up, we need to go further with it. You said you sent out, Chris, 2 notices, and they don't show up. That's completely disrespect and a violation right there.
Mr. Rustin, did you receive...
And you know what? I have a passion. You have to forgive me. I have a passion about people when they come up here and give up their time and they're trying to get their rights and we're saying we are education, teaching people, and people ignore us. It's very offensive to me, and it's offensive to the whole city and to our residents. And so, I don't want to continue it. I really don't want to continue it. Let's go on.
Mr. Rustum, have you received any response from the Library Commission as to intent to be here or not be here?
There wasn't any message forwarded to me.
Okay, Ms. Cawthon, you had something you wanted to say?
I am inspired by what Ms. Williams said. I would like to rescind my request for a continuance if that's appropriate, and go ahead, even though there are only 7 people here today.
I believe that's appropriate, and you may proceed. You have 5 minutes.
Okay. I'm going to start out by showing my complaint is about the refusal to permit me to present public comment. I've got a video, and I've also got, there's a transcript. It says transcript at the top, and it was done by a friend of mine who's a court reporter. So if we could just begin with me stepping up to the podium and general public comment.
Good afternoon. I'm Sue Cawthon. I'm talking about North Beach, but not about design. I just wanted you, I think you all know that I head a coalition of groups who are concerned about the present plan, and I've passed around.
Can you hold that until we get to that item? That's a North
We
Beach
talked to
item.
the city attorney, and
This is a North Beach item. Will you hold it until we get to it, please? Will you hold it until we get to it, please?
The North Beach item.
You hold it? Are you not listening to me?
The North
Sit
Beach,
down.
The North
Sit
Beach
down.
item is
Sit
about
down.
design.
Please sit
It's not
down.
about
Please sit
design.
down. Please sit down. Please sit down. Thank you.
Okay.
I've asked other people to hold their items until the North Beach topic comes up. If the other member of the community can hold it, you can as well. Thank you very much. North Beach item comes up next on the agenda. Public comment. I believe I read it. It says, allow members of the public to comment generally on matters. Thank you. Additional public comment.
Okay. How much, was there a countdown clock here? How much time do I have?
Through the chair, 3 minutes, 19 seconds.
Oh, no, stop. I mean, it was what Peter said was great, but he can say it today. How much time do I have?
Through the chair, 3 minutes and 9 minutes.
3 minutes? Okay. So
Proceed.
I'm just going to say that the general public comment issue item said for items under the jurisdiction of the commission. So number 1, I should have been allowed to talk. 2, what I wanted to say, the chair never had a chance to find out because she wouldn't let me tell her that I was. The second item was about North Beach Library design and a peer review. They had an architect and a librarian, and they came in and talked about the layout of the library. The reference desk should be here. There should be more windows. The room shouldn't be so crammed together. It's too high. It's too low. It's too bulky. That's design. That was what the second item was titled. It wasn't titled North Beach Library Project. That would have, of course, meant that I couldn't speak about it in general public comment, although Mr. Warfield thinks I could have. But in any event, I said this is not about this design. Design is the second item. This is not about library design. She simply wouldn't let me speak. And you know, there is a section in the Sunshine Ordinance, 67.4A, I believe. It says your agenda item should be sufficiently clear so that a person of average intelligence should know what it's about. In fact, she permitted people on the second library item, which is on page 3, North Beach Library Peer Review of Design, I think it's called. She let people talk about everything and anything. The item was library design. That's why I thought I could talk in general public comment at the beginning. In any event, general public comment at the beginning is for general public comment on any item within their purview. And if you notice the agenda on page 103, it says at the top, and I've circled it, any item within their purview would be permissible. The next meeting, which is June 18th, and it's on page 104, they've added some words. They've added any item within our purview which is not otherwise on the agenda. So this shows that they knew that their first item was not sufficiently clear to restrict people from talking on another item. And in any event, What I wanted to say had nothing to do with North Beach library design or the peer review of it. I should have been allowed to speak, and the library is in violation of the Sunshine Ordinance. I hope you will find that as well, and I'm very disappointed that they didn't even show up or call.
Thank you. Is there anybody here to present facts and evidence in support of the complainant?
Yes, hello. My name is Joan Wood. I was so appalled at the reaction of the president of the Library Commission that I was compelled to write a letter to the mayor because I realized that he's the one that appoints the members of the Library Commission. I worked for the city for 31 years, and naturally I'm aware of how we're supposed to treat the public, and it was outrageous. The video doesn't really express how loud Ms. Gomez was. I came to this meeting about 3 or 4 minutes late. I was just coming down the aisle, and I heard her shouting at Sue Cawthon, who was partly into her remarks. And the letter that I wrote to the mayor, I don't know if you got a copy of it or not, but I thought it was about 8 or 9 times. I counted on the video, it was 13 times. She got louder and louder. She was bellowing. On the video, I was in shock, and I flashed on, way back in college, a respected professor of mine said that whenever you see an injustice, even though it's difficult and nobody else is doing anything, you have to speak up. However, I actually was frightened. I can't say why, because if my brain was engaged, I would have realized there probably wasn't anything to be frightened of, except that she probably wouldn't have let me speak when I got to whatever I was going to speak about. But it was just frightening to see somebody completely out of control and losing their temper. And I'm here about that. It was just inappropriate that Miss Jewel Gomez is the head of that commission. I don't think this is the right venue to complain about it, but Ms. Cawthon asked me to be here, and I think she submitted the letter that I sent. It was just shocking and outrageous. Thank you.
Thank you. Is there anybody else to present facts and evidence in support of the complainant?
Good evening, Howard Wong. I was present at the Library Commission. That was actually the first Library Commission that I ever attended. And it was a little bit surprising compared to many of the other committees and commissions that I've attended, which generally have a very professional decorum. The net effect of that outburst, I guess would be the proper word, was that after that, in general comment, there was a hush in that audience, and I don't think anybody spoke after that. A very disturbing fact in a public forum where there was a perception that any public comment wasn't welcome. But at first I said, all right, the agenda did say North Beach design. And I said, well, maybe there's a reason behind this. But then as the evening proceeded, I think I started to sense there was really an orchestration of a commission hearing, which I found very, very deeply disturbing. In other words, I think there was a sense that there was a need to guide the forum towards a certain pattern to achieve a certain result. As the evening wore on, the design presentation was very nice. It was a very, very, very good quality architectural PowerPoint presentation, beautiful drawings, followed by two design reviewers who read their fairly favorable comments with some criticism, but fairly favorable. And then followed by a public comment period where there were suddenly many supporters of the library, not even speaking to the design itself, but just coming out and say, I support the library, I support the library, and these included paid library staff, friends of the library, who suddenly appeared just to support the project and not even talk about review. The folks who were there to criticize the design did have their chance to speak, but were far outnumbered. We had almost no notification of that meeting. Apparently, it's common process. I later learned that the Library Commission sends out postcards to those who have attended committee meetings only a few days before a commission meeting. So we were scrambling to get somebody to attend, and here we were outnumbered by a well-orchestrated number of people. So I thought there was something wrong.
Thank you. Thank you very much. Is there anybody else to present facts and evidence in support of the complainant? Seeing none, the chair will ask one more time. Is the respondent present? Okay. Is there anybody here to present facts and evidence in support of the respondent?
Your Honor. Mr. Chair, I just want to point out that the library did send a letter that was submitted and is part of your packet. So I don't know why they're here, but all I know is that they have their position stated in the letter.
Okay. And could you remind us what page that's on in our package?
Sure.
Page 95.
Page 95.
97. 97.
Okay.
The only point that would be, I would ask the Commission Task Force to consider is whether or not Sue Cawthon was able to, other than the fact of what had happened to her, was she able to present the information or present the public comment that she wanted to? It's unclear whether she was able to, from what we saw. The question is what happened afterwards. If she didn't feel that she was able to, then I think that's irrelevant and it's an issue, considering the reception she got initially.
I see. Thank you. Committee? Member Cawthon, Mrs. Cawthon, please approach the microphone. According to what we've been presented here, you were eventually able to present the testimony you wished. Is that correct?
No, it's not.
You were not, when item number 2 came up, you were not invited or allowed in any way to present your remarks?
I did present public comment, but in the first item, I wanted to talk generally about a group that I head, that's a citywide group that's trying to preserve some of the historic libraries that the library wants to demolish. I wanted to talk about issues of the closure of Mason Street, which is part of the North Beach project. There were a lot of things I wanted to talk about. That's why I was happy when I saw that I would be able to speak during general public comment. And then I had my other remarks reserved for the for item 2, which I knew I would be able to say something on. In fact, I passed out a document called Save the Triangle Park. If anyone doesn't know, the triangle is a little parcel across the street from the library that was taken by eminent domain to be open space, and the library wants to build a huge building on it, so big that they have to close Mason Street to do it. So that was one of the things that the Safe Triangle Park piece that I passed out said. I also talked about the fact that this parcel was purchased by eminent domain with $2.8 million worth of open space fund money.
Okay, but during your remarks, in discussion of item number 2, when that item came up, during your remarks, were you able to discuss these other things that you wanted to do?
I didn't have time. I only had 3 minutes. I thought I would have 6 minutes.
Okay, and you had to limit your remarks during item number 2 to
what I could squeeze
to the North Beach issues, to the North Beach design issue.
Well, since the chair was letting people speak about anything they wanted, the agenda item said peer review of North Beach Library design. So in my mind, design means the way a structure is laid out, the way the rooms are laid out, whether it has windows, how the building looks. But the chair let people speak about anything they wanted to talk about. So I talked about things other than the library design, but I only had 3 minutes. So I was deprived of the 3 minutes at the beginning of the meeting, which said that general public comment was for any item within the library's purview.
Okay, thank you. Committee?
I would like to make a motion that we find the Library Commission in violation of allowing public comment.
6715A.
I believe so.
Can I amend for 6721E, failure to appear?
Could we speak into the microphone, please?
Can I amend that to include finding violation of 6721E for failure to appear?
Yes, of course.
Has there been a second?
I will second that motion.
Okay. Is there general public comment?
Yes, Peter Warfield, Library Users Association. I'm a little bit troubled by some of what I'm hearing. I'm glad that there's a violation being suggested for 6721E, which requires the department to attend any hearing very clearly, and I hope somebody will read it. I would like to suggest that you find violation of 67.15A, which requires that public comment be permitted on items of interest to the public that are within policy body's subject matter jurisdiction. That's the basic rule. I would also suggest that this was a violation that was willful, which is a violation of 67.34, and that this was a violation based on the content of the speaker's statements, which is also a violation that is prohibited. I believe it's in 67.15. Why was this a willful violation, one based on the content? The immediately preceding speaker, and I have the tape of the thing here, which you can play there or I can play for you, was given 25 seconds to speak before she sat down. She was interrupted at about 15 seconds by the president of the Library Commission politely asking her if she would mind holding her comment about North Beach until later. She then talked for another approximately 10 seconds, saying that she just wanted to say how wonderful the planning was for North Beach and so on and so forth, and was allowed to do that and ended up speaking for 25 seconds. When the next speaker, Sue Cawthon, came up, she went for about 15 seconds before you started hearing the shrieking, and that 15 seconds, she was only about 3 seconds into the statement that she had a coalition of folks who, and now she was tipping off the president that she was in opposition, at which point Jewel Gomez started that harangue and that bellowing, and one might say bullying, to get her to shut up, and would not let her get a word in edgewise of any kind. It was radically different from the treatment the immediately preceding speaker had gotten, and which I would be glad to play on the tape, and which I think you should listen to. Second, there were a whole range of reasons why the president should have known this was inappropriate. First of all, the similar thing had happened to me 2 months earlier, and I had protested a violation of sunshine, but ended up getting basically shut down on that subject at that time during general public comment. Second, what you saw there, and if you noticed, the deputy city attorney who sits at every meeting of the Library Commission physically got up and walked toward the chair, the acting chair. She was going to tell her what she's doing is wrong. I do not recall ever seeing the deputy city attorney do that. I myself, following Sue Cawthon's being shouted down, told them there was a violation, and then Sue got up again afterwards to try and speak, said she wouldn't provoke the chair by trying to speak about. there were many opportunities for the president of the Library Commission to understand, had she taken any interest, that there was a violation going on and that she should have allowed Ms. Coffin to speak on basically any subject, because that's what the library agenda item says, any subject
Could
within
you
the
wrap up,
purview.
please?
And so I would urge you to listen to those portions, and I've queued the tape up, and find additionally that there was a willful violation and that it was based on the content that Ms. Coffin got not only the much rougher treatment, but the absolute cutoff within about 3 seconds of her mentioning that she was opposed, and then wouldn't be allowed to say anything further, unlike the previous speaker who was treated much more gently and allowed to speak much longer.
Okay, thank you, Mr.
Thank you
Warfield.
very much.
Okay. While the tape might prove useful, I think that had you wanted to present it, it should have been within your 3 minutes, so I will ask you to be seated, please. Is there further public comment on this matter?
Good evening again. Clearly, the president of the Library Commission doesn't appear to be fit to be on the Library Commission. But I think a bigger issue raised by this complaint, though, is what the role is of this Sunshine Task Force when one of your members files a complaint. Can you really be fair and impartial?
That's our job.
I don't think so. So what I suggest is that perhaps maybe the city attorney or the Ethics Commission would hear the matter when one of your members is filing a Sunshine Ordinance violation. Thank you.
Thank you. Well, in response to that, I will say that we have given both sides an opportunity to appear and present their sides. One side has chosen to do so. Sir.
Hi, Kimo Crossman. I'd like to play some recording of the SFPL discussion. This is the previous speaker.
My name is Tricia DeFries, and I live in North Beach, and I'm here just to show my support for the new library, and basically also to represent many of the mothers. I've been raising my children there for the last 7 years, taking them to the park and to the library quite frequently. And I'm really quite saddened by the state of the existing.
Can I ask you to hold your comments till we get to that item?
I just want to say that I'm in support, and I'd like to see something new and fresh.
Thank you. Thank you.
Good afternoon. I'm Sue Carson. I'm talking.
And I want to say that I have attended some San Francisco Library meetings, and I have seen the woman who now is the chair of that body be very dismissive to the public. I actually saw her. She had a glass of ice in her hand, and when a member of the public came to speak, she rattled it over the speaker for the whole time he was speaking, so that nobody could hear what he was saying. And it was clearly, purposeful. But she didn't want to get a complaint against her, so she did it this way. It was kind of an underhanded way of preventing someone from hearing for what she said. So I can tell you that if you attend the Library Commission meetings, you'll see that they're very well schooled on what is and isn't sunshine violation, and they sometimes push the limits on what's acceptable. From what I read in the complaint, I think Ms. Coffin has a valid point.
Okay, further public comment? At this time, since there is nobody from the city and nobody in support of the city here, Ms. Coffin, you now have 3 minutes if you wish to present any concluding or rebutting remarks.
I just wanted to reiterate what some of the public commenters have said, that I go to all the Library Commission meetings. I chair the Board of Supervisors Library Advisory Committee. The Library Commission did not want us to be created. They, in fact, testified against us at the Library Commission, but the Board of Supervisors unanimously voted to have a quasi-oversight committee for the library. So that's number one, the possibility of being a boil on their forehead. I don't know. But I'm always totally polite when I speak to these people. I tell them in general public comment what we've been doing. I gave them copies of our annual report. But I have found, with a few exceptions, that there is a sense of hostility toward people who don't always agree with them. And the Library CAC's role is to make recommendations to the supervisors to improve library service. And then that's sort of, as I say, a thorn in their side somewhat. So I think that it just really played out at this meeting because there was a very controversial item before the body. It was a very tense atmosphere, and I think they wanted, as Mr. Wong said, they hoped everything would go smoothly, and they sort of wanted to orchestrate an outcome that I was not contributing to. But in fact, since general public comment at the beginning permitted someone to speak on anything within their jurisdiction, that alone should have permitted me to say what I wanted to say.
Thank you. Committee?
I just have a point of clarification. I heard a motion for 6715A, 6721E. 6715A, I heard was seconded. Was there ever a second for the friendly amendment?
Okay, is there...
Let me just point out to the members of this body that 67.21E deals with an authorized representative of the custodian of a public record requested shall attend any hearing and explain the basis of its decision to withhold the records requested. I don't think it directly applies here.
Can I make a friendly amendment then? To add
Member Chan.
willfully
Willful violation?
Violation.
Under 6734?
Correct.
Okay. Further discussion? I want to make some comments. Under the Sunshine Ordinance, and I believe under the Brown Act, the agenda here, the Library Commission agenda here was fairly clear and forthright. If you look on page 103 of our packet, the June 4th meeting, peer review of proposed design for the North Beach Discussion Library. So item 2, I think is fairly clearly stated there. Ms. Coffin wanted to talk about other things regarding the North Beach Library and other libraries throughout the city. So I believe that the commission president violated sunshine here by preventing Ms. Coffin to give public comment on an item, on a non-agendized item that was within the subject matter jurisdiction of the commission. I also think it was willful. And the way Member Coffin, Ms. Coffin was treated at the meeting, I just think it was inexcusable. And the chair intends to send a letter to the Library Commission stating in no uncertain terms what the sentiment of the task force is on this matter. Member Williams, and then did you have a comment, Member Chan?
Chairperson Nee, I totally agree with you. If there was some kind of violation for the conduct that she portrayed, Ms. Gomez, that was totally, many meetings I've been through, I've never seen anything like that. I was totally shocked to see something like that, and I would hope that the committee task force members would have you to write a letter to Ms. Gomez in her own way and tell her that that was totally unacceptable. People shouldn't be treated like that. I don't care who it is, it's general public, and I hope I never have to see anything like that again, so please write a strong letter.
Member Chan and then Member Knebber.
Just want to echo what Member Williams says. And, this is straight willfulness. And just by them not showing up, they're admitting guilt.
Member Knebber.
I guess I'm still a bit unclear. I've heard a lot of different things that were not actually put into motion. I just want to be clear about what's out there on the table now. Could we find out what that is?
6715A
Okay.
and 67.34. May we have the roll call, please, on the motion?
On the motion, Member Craven Green. Member Craven Green excused. Member Cawthon. Member Cawthon excused. Member Washburn. Recused, sorry. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson. Member Johnson excused. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, aye. Member Chu. Member Chu absent. Member Nee.
Aye.
Member Nee, aye. Mr. Chair, we have 6 ayes.
Thank you. Before we move to the next item, the chair will declare a 5-minute recess.
Yeah.
Text.
Yeah.
Huh? Oh, really?
I still think there's other things there, but yeah, I know. What I think, I can't make it. This is. Yeah, we need to start this over. Relax. Yeah. Yeah.
Yeah, hi, this is Nick. I got a call from this number. Pardon me? All right, on Folsom. Oh, right.
You're growing your hair out.
Yeah, it's summer.
I'm growing it short, you're growing it longer.
Okay. Thank you for letting me know that. We're just taking a short recess in our meeting, so I just checked my messages. I'm glad you let me know that.
Actually, I did it.
Yeah. So anyway, I will shred your information. Utmost confidentiality. And thank you for the opportunity. Okay. Have a good evening. Okay. Bye-bye.
That's kind of cool. Plus, then, you don't get out of the habit of smoking and all that. Oh, really?
I'm caught up. Hey, technology grant.
Oh, I know, absolutely. I've been getting in touch with my best friend from middle school through Facebook.
Facebook. I love
yeah.
the Facebook.
And then classmates.com.
Yeah, I run into people that I've heard from for years.
Yeah.
Hey, you, what are you doing?
Spent 2 hours of the time talking to
So, but that's just a short-term contract. Yeah, they don't have enough. I thought I was out in case when she got laid off in the office and everybody in technology over off. But if you do like a 2 months notice. So I'll take it back, kind of like word out. It's just notice ended. So, maybe they every week or whatever. Then I get a call from a friend. So it was kind of like, I wish I would have known that was going to happen because I was enjoying that time. Instead I was like, I don't know what I'm going to get another job. So I
Yeah, what's up with that? She was really good with her. Hey there. It is going to be a late one, actually. Did you see the text? Yeah, we're just taking a little recess now.
Actually, I think remember June not telling you? I think she was going to go on vacation or something with her family. I think she mentioned that to me. I'll go back and check my emails on that. See if
I used to carry a pigeon around.
You might want to change her app.
No, it's
I'll have to
before it was like,
review
okay,
my
what's the
emails
phone?
on my knowledge.
Or you just didn't contact me. I'll see you at 8 tonight.
Yeah, and if I'm late, that's how it is.
Could the task force members please return?
Member Williams?
Member Shannon.
Member Coffin?
Where's Allison?
No, there isn't. It's the summer of love.
I'm surprised there were 6 members.
I don't know.
Well, hey, wasn't it 67 though? Summer of Love.
Yeah. 67. Yeah,
The
the
year-
rate was so high, he forgot.
Yeah, right. Yeah, I graduated from high school in 67. Yeah.
We are back in session. Mr. Clerk, could you call items 8 and 9, please?
Item number 8 is the determination of jurisdiction on complaint filed by Ann Grogan against the Police Commission for allegedly not opening meetings to the public.
Okay. Member Chan?
I'm going to recuse myself because of my relationship with the police department.
Okay. Without objection?
Objection.
Thank you, Mr. Chan. Is the complainant present?
Well, let's find jurisdiction first. I move that we do so.
Okay.
I second.
Okay. Moved and seconded. Is there public comment on the jurisdiction question? Seeing none, is there any comment by the committee? Seeing none, roll call, please.
On jurisdiction, Member Craven Green. Member Craven Green excused. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Caneva.
Aye.
Member Caneva, aye. Member Johnson. Member Johnson excused. Member Chan. Member Chan recused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, aye. Member Chu. Member Chu absent. Member Nee.
Aye.
Member Nee, aye. Mr. Chair, we have 6 ayes.
Okay. And item number 7, we hear the merits of the complaint. Is the complainant present?
Member, actually, it's member number 9.
Yeah, item number 9. Okay. Is the complainant present?
Yes.
Thank you. Is there someone here from the respondent? Thank you, sir. Please approach the microphone. Thank you for coming. You have 5 minutes.
Thank you, members, for agreeing to consider my inquiry and complaint.
I'd like to briefly explain the committee or the government agency I wish to attend and whose documents I wish to review. It's a steering committee, called a steering committee, and it advises on a present research study being conducted by an outside Boston group. The study surveys the cost-effective crime prevention neighborhood policing services known as the Patrol Special Police Officer Program. It's a program well respected by many merchants and residents in San Francisco who are private clients of this neighborhood policing program and who pay for those services. Services are additional to those provided by the overburdened SFPD, not at all in conflict with them. And the SFPD has recently faced some attrition, cutbacks through attrition, and we're now facing a critical deficit in this city. Therefore, it's of grave interest to citizen taxpayers to use every possible resource to address our public safety needs. The Boston study is about how this Patrol Special Police Officer Program can and should serve San Francisco's public safety needs, especially during our growing fiscal crisis, and how it should relate to the San Francisco Police Department. The steering committee, as Lieutenant Riley recognizes, and he responded on behalf of the Police Commission to my complaint, is composed of 2 San Francisco Police Department members, 1 supervisor, 2 police commissioners, and the city controller. And as Lieutenant Riley states, this committee provides high-level policy guidance to the outside Boston research group. Appendix A, submitted with my complaint, summarizes the Boston study, and it verifies that this steering committee can even change the direction and the scope of the study. It can come up with negative recommendation, it can come up with a neutral one or a positive one regarding the patrol specials. Now, according to what I was told by the Boston research director when I asked to attend the steering committee meeting, the policy guiding body, the city controller admitted that the steering committee is a passive meeting body as defined by the Sunshine Ordinance, and no one has raised an objection to that characterization. It is apparently a passive body. After careful analysis of the ordinance, I fail to see any exception that would justify the steering committee to close its meetings to the public or maintaining its paperwork secret from public access. Thus, I come before you to determine my request. Now, Lieutenant Riley does not apparently object to your jurisdiction today to decide if the public has a right to attend that steering committee and observe its deliberations. But what he does seem to argue is that the Police Commission is not the proper party to have been called before the task force today. In support of that position, he states 3 things: that only 2 police commissioners are on that steering committee, which has 5 total members, that those 2 police commissioners have only a limited role and responsibility on that steering committee, and that all meetings are actually called by the Boston Research Group and not the 2 police commissioners sitting on that steering committee. And he suggests that the police department is the proper party to answer here, because apparently a police department officer or administrator signed the actual contract with the Boston Research Group. Now, that position is most curious to me in light of 2 emails, one from Commissioner Sparks, who was the previous president of the Police Commission, and one from Lieutenant Lum. Lieutenant Lum is the San Francisco Police Department liaison officer for the Police Commission to the Patrol Special Program. He is their liaison for administrative purposes. Both emails were sent in early March concerning the startup of the Boston study, and Commissioner Sparks on March 6th wrote an email and addressed it to Patrol Special Police Officer Jane Warner. It definitively establishes that the Police Commission is the responsible party when it comes to the administrative conduct of the Boston study, and I'm quoting from her email. I have a copy of it for the task force members. She said, "The Police Commission is the regulatory body of all patrol specials and as such has the sole responsibility of determining if, how many, and who shall be the members of any and all steering, work, or advisory groups." She says that's her responsibility. And Lieutenant Lum added, when I asked to be consulted by that body as a client of the specials, he passed my request directly to Commissioner Sparks. He did not pass that request to his commander within the SFPD, and he didn't pass it to anyone who was apparently in charge of the study of the SFPD. So it seems to me quite clear that the authority here is lodged in the Police Commission, that is the regulatory body over both the SFPD and the patrol specials.
Okay, could you wrap up,
One
please?
final comment. A private citizen cannot easily ferret out who is in charge of directing research studies, writing the checks, and paying out of taxpayer funds. A private citizen really can't be expected to sort through the labyrinth of city contracts, bank accounts, and legal authority to determine those things. The Police Commission knows who's in charge. The Police Department knows who's in charge of this study. And to hold otherwise would simply be game playing, in my opinion. In one short month, this steering committee's work will be done. If this commission can reach a decision and say that this is a policy body that should be open, well and good. But within 1 month, the steering committee's work will be completed and the public will have no access to its deliberations.
Thank you.
Thank you.
Okay. Is there anybody here to present facts and evidence in support of the complainant? Seeing none, would the respondent approach? And, sir, in light of the length of the complainant's presentation, we're going to give you an extra minute.
Thank you, Mr. Chairman. I'm Lieutenant Joe Riley. I'm the Secretary of the San Francisco Police Commission. Appearing tonight on behalf of the Commission. I must say that I was not aware of the emails that Ms. Grogan has just referenced. There's new information to me. That being said, I just want to say that the complaint that I have before me from the Commission deals with public records violations. I don't really see in the complaint a public meeting violation alleged. I will say at the outset, and as I've noted in my earlier correspondence, I'm not sure that the Commission is the proper respondent here. The Commission did not negotiate this contract that created the steering committee, the contract for the study of the Patrol Special Officers program, and is not an immediate party to it. The steering committee was established by virtue of this contract through the Office of Contract Administration with the Assistant Controller's Office and executed with the Police Department. The Commission's only connection with the steering committee is that 2 of the 5 members are police commissioners. There's only 5 members on the steering committee. I do have a copy of the contract here. As the Commission's custodian of records, I could say that the Commission is not in possession of any records related to the activities of this Commission. Therefore, it would be very difficult, if not impossible, for me to respond. Ms. Grogan will tell you that she has made records requests directly to the Commission office in the past, and she has received same-day service from us. So we are responsive where we can be and when asked. As indicated, there seems to have been a discussion at some point in the past that characterized the steering committee as a passive meeting body. I do not agree with that, and I'll do so for the following reason. Steering committee is not an advisory committee created by the initiative of a member of a policy body or the mayor or a department head. It's created by virtue of this contract. It directs and supervises the work of the contractor. Now, in the negotiation of the contract elements, I would have to surmise that the contractor be the people that would want this kind of direction and supervision. And it was the intent of the steering committee to provide just that. So the information flowing from the work of the committee does not go to department head, does not go to a policy body, it goes to the contractor. The contractor's work is yet to be completed. I would suggest that the contractor's work product is still their intellectual property, and at the point at which they have completed their task and they deliver their work product under the terms of the contract to the police department, who is the other party in this contract, then that would be the documents that would become public. At this point, members of the board, I have no further comments to make other than I did have a request for a continuance of this matter before the board, and I don't want to disappoint the conspiracy theorists in the room, but it was nothing more sinister than me trying to take a vacation. However, we did keep the appointment as requested, and we are making our appearance tonight.
Thank you. And we do appreciate your being here.
Thank you, sir.
Is there anybody here to present facts and evidence in support of the respondent? Seeing none, committee? Member Neber.
To me, this whole thing hinges on this idea of the definition of a passive meeting body, and is it just a offshoot of this contractor, or is it a creation of the police commission? And that's a little tricky for me. I'm right from the information presented and from what I've read, I am kind of leaning toward somebody has initiated this contract, and I think by extension that makes it this body an extension of the police commission. That's what I'm leaning for. I'm not strong enough at this moment to make a motion, but that's where I'm leaning.
Okay. Lieutenant, could you approach the microphone, please?
Yes, sir.
Yeah. Who created the steering committee?
To my knowledge, sir, the steering committee was created as one of the provisions of the contract with the Public Safety Strategies Group, PSSG, who is conducting the study.
That's the Boston organization?
That's I believe I'm not sure exactly where, I believe they are the Boston, from that vicinity. They've done other work for the police department.
Okay. So it is under contract with the city that this was created?
Yes, sir. In my role as the custodian of records for the police commission, I had to familiarize myself with all the details of this contract because I have never seen it before. And I can tell you that the commission office is not in receipt of any documents related to the contract or the activities of the steering committee or the work of the Public Safety Strategies Group. And I do have a copy of the contract here for your edification, for the committee's or the board's edification, if they so wish to see it.
Okay. One other question. The complainant alleges the commission failed to provide public records relative to the steering committee's meetings with the Public Safety Strategies Group. Where do the steering committee's records reside? Is it with the police department, the police commission, with the Public Safety Strategies Group? Is the steering committee an entity unto itself that keeps its own records? Where would those records reside? What's the normal default repository of those records?
Sir, I'm not in a position to really answer that other than to say the commission is not in receipt of any such records. Reading the contract, it appears that the contractor is the facilitator of the steering committee meeting, so I would only be guessing. I'd have to be guessing as to where these records lie, but so I would be hesitant to offer an answer at this point.
But the contractor is doing the work of the city, correct?
That's correct.
Okay, thank you. Any other comments or questions?
I have a question for Ms. Grogan.
Member Goldman?
Please.
Ms. Grogan, please approach the microphone.
Can you supply us with that email that you referenced?
Yes, and I did give Lieutenant a copy. And neither is this nefarious. Just this morning in preparing my testimony, I happened to run across this email in my file copy, and so I copied it. I thought it was quite relevant. Mr. Reston, could I give this to you, please? I have copies for the members. I would reiterate that the city is a party to this contract and is spending taxpayer money here. And is conducting city business. The steering committee is conducting city business of a policy level. The report that will be drafted by the Boston Study Group is going directly to the police commission for their deliberation. First a draft report, second a final report. So it is going direct, not to the police department, but to the police commission for their overall policy guidance and deciding how to handle the regulation of the patrol special program. The police commission is the one hearing the results, and it is the body regulating both of these police offices, at PSFPD and the patrol specials. Who calls the meetings seems to me not relevant. The Boston Study Group, of course, is going to call its policy advisory body of city employees and appointees. That's not an issue here. The issue is this is a city body with employees and appointees. It's dealing with policy relating to public safety.
Thank you. You've answered the question.
Thank you.
Thank you. Further comment or questions? Member Knever?
I'm leaning more towards this being because it is under contract from what I'm seeing here as a passive body under the jurisdiction of because it is under contract with the Police Commission or the City of San Francisco. So I am more in favor of a violation, but at that time I would like to present one.
Member Cawthon?
I agree with Mr. Kniever. I mean, I know a little bit about passive bodies, and it does seem to me that within the general passive meeting bodies, it does seem within the general context of who does what and who is regulating what, that this would come under the rubric of a passive meeting body, and I think it's very, very disappointing to me that they wouldn't that they canceled their meeting then rather than let Ms. Grogan sit in.
Okay. At this time, I will call for public comment.
Hi, members. Kimo Crossman. I just wanted to remind you of the history behind the creation of a passive meeting. That was created in Prop G in 1999 to prevent city policy and functions being done off the books by private or nonprofit entities. The particular case that occurred was there was a non-governmental entity that was reviewing the architectural plans of the War Memorial Museum, and I think there were some policy member bodies that were there were members of that committee, but and they were obviously making recommendations on how the architecture should be changed or revised, and so that's why they wrote the whole provision for passive meeting bodies in there to expose that to a transparent process. Let me point out to you that passive meetings, you can't have a passive meeting if it's only city employees, except for some special circumstances. The idea is that a department head can meet with someone besides the department head lower can meet with other employees. City employees can meet and talk about issues without having to open it to the public. But when a non-city employee attends, that goes out the window. And in here we have contractors that are attending and leading the meeting. So if they are able to attend it, which are non-city employees, then other members of the public should be able to attend and are clearly able to attend as well. And so the provisions for saying passive meeting body doesn't kick in with this only employees doesn't work here because we have policy body members and non-city employees attending the meeting. So it's very clear to me that, and also there's even a provision under 67.4B that talks about even if it's only employees meeting, if it relates to the furtherance of the safety of the public function, that is disclosable or there's transparency, it's a passive meeting. So nonetheless, I have a question. How can a non-policy body have a closed meeting with non-city employees? How can this contractor, they said that they wanted to have a closed meeting because they were going to talk about personnel issues. How can they have it when there's non-city employees in the meeting. I would say that if non-city people can attend the meeting, then they can't choose who can attend. Either everyone can attend, or only members of the city agency can attend. So, for those reasons, I would say this is clearly a passive meeting, and I think you should find both SFPL and the commission in violation.
Thank you. Further public comment? Okay, at this time, sir.
I just want to say that, just echoing what Kimo Crossman says, this is clearly a passive meeting body. You know, why do we have sunshine, period, right? Is to have open government, being open to the public and be open to the citizens of San Francisco. And that's why it's been created. So basically, it's a clear violation. Thank you.
Thank you. Further public comment? Seeing none at this time, I would invite the respondent to present any concluding remarks and rebuttals. You have 3 minutes if you wish.
Thank you, Mr. Chairman. Again, I'll just reiterate what I've said before. The Commission is not in possession of any documents related to the conduct of the steering committee, the activities of the steering committee, the progress of this report, or any other such related issues, or any other such related documents, I should say. The Commission's only connection with the activities of the steering committee are the fact that there are 2 commissioners that are members of it. They're advising a contractor. The information is not going the other way in advisory mode to the Commission. So the contractor has yet to finish their work. The contractor has been characterized as a non-city employee who is attending these meetings and therefore making it a passive meeting body. The contractor is just that, the contractor. I believe that the contractor understands that the steering committee exists for the benefit of the work of the contract, and the end result resulting study, which has yet to be completed, has yet to be produced. There are ample opportunities at all levels for the public to weigh in on the matters of this study. It's a regular agenda item at every police commission meeting, the study of the Patrol Special Officer Program. And the contractor and other members of the committee have been in communication with various people at various levels regarding all aspects of this. So for those reasons, I would hope that the committee would take the Commission's point of view on this and vote in our favor. Thank you.
Thank you. Complainant, you have 3 minutes.
2 points. Documents will be submitted to the steering committee by the Boston Research Group. I'm not referring to minutes taken by the steering committee or anything like that. I think that I should have access, if this is subject to the Sunshine Law, to the documents that are submitted for them to address on policy issues. Clearly, that's referenced in the appendix and the description of the study. Whether or not the public has a right to weigh in on the Patrol Special Program or the conduct of the police department at regular police commission meetings, that's an entirely different matter. That's not before the task force. I want to observe, and other members of the public I know want to observe, the policy discussions of the ongoing study as it develops. They can change the entire scope of the policy in the study. They can recommend negative things. I want to observe those policy discussions. That has nothing to do with testifying in the police commission or observing the police commission discuss the general program. Thank you.
Thank you. Mr. Loretti, you had a comment?
I think that based on the testimony here, there might have been a need in order to amend the complaint to allege not just public records violation, but access to a public, should be a public meeting. The complaint does just say public records, but it sounds like the complaint, and I think the parties have been raising this all along, that this appears to be more of a discussion about participation or observation of a session, which may or may not be a public meeting. So I think to conform with what the testimony is, that maybe if that is the intent of the complainant, that the complaint should also go toward the access to the meeting rather than just the public records.
Well, okay. do we have, do we have the flexibility here to add that to the complaint? I don't think we do. Correct me if I'm wrong.
Well, that's why, if the parties agree, then you do. If the responding agency says, no, this was always noticed as a violation of public records, then you don't.
Okay.
May I clarify or question? I'm confused. The letter that I wrote, the subject line says, request, inquiry, or complaint to attend meetings and review documents and minutes, if any, of the steering committee.
Page 120 of your...
Attend meetings and review documents. How much more clear could I be?
The complaint says public meeting violation, no. So that needs to be...
There's a cover letter to Ms. Cawthon that was directed to Ms. Chu, and there was an attachment to it.
121, actually.
It's the attachment says inquiry and/or complaint of Ann Grogan concerning public access to meetings and relevant documents of the steering committee.
Okay. Do you wish then to amend your complaint to include the denial of access?
My complaint.
Well, not according to what we have here in the memorandum.
What I submitted was a letter dated May 19th, and it was sent on June 4th to Ms. Chu, and it was titled Inquiry and/or Complaint, but it was done on my letterhead. It was not
121. We have
submitted on a formal
121
complaint form.
That's why I'm a little confused, because I thought that it did include that.
The chair, the chair is going to find that the summary here on page 109 is incomplete. The chair is going to rule that this complaint does include denial of the ability to attend a passive meeting, a passive body meeting.
Thank you.
Please.
Thank you, sir. As you recall, the Police Commission asked for a pre-hearing conference on this matter to clarify that very issue. And we did appear, I believe, on July 14th. However, the complainant did not appear that day. So we did not get that kind of clarification that we asked for, and we specifically asked at that time what the nature of the complaint was. Was it public records? Was it public meeting? And it's only being resolved at this point in time. So I did appear that day, but we failed to get the information at that point in time that would have resolved this issue.
Well, okay. The complainant had sent her letter to the chair of the complaint committee on May 19th. That's the date of the letter. So that should have clarified it right there. And it's regrettable, very regrettable that it did not. And this gives us a little bit of a thorny. This creates a problem because obviously the respondent has been under the misimpression that the public meetings part of this was not going to be addressed here, and therefore did not have adequate time or resources to prepare a defense or a response to the complaint on the public meetings aspect of this.
May I address that specifically?
Not at this time. What I think might be a good idea is to move forward with part of this and then continue the second part to our next meeting.
But could I at least point out, sir, please with your permission,
Go ahead.
on the 15th of May, I wrote Teresa Sparks a letter asking her to facilitate this, hoping we could do it informally prior to filing my complaint with you. And in the Ray line, I said, request under the Sunshine Law to attend meetings and review documents and minutes of the steering committee. It's my understanding that this letter to her, followed up by the letter to Ms. Cawthon and Ms. Chu, is my complaint. I'm confused about what you're even talking about. This was my complaint on my letterhead dated May 19th to your task force.
I understand that.
Okay, and it was pointed out to the police commission.
I understand that, but what we have here in our cover sheet, the memorandum detailing the complaint here, this is on page 109, complainant files a complaint. This isn't your fault. You have every bit of sympathy with us, but this is, we can sympathize, but there are there are protocols that we have to observe here. And what I am going to propose again is that the committee can rule, that the task force can rule today on the public meetings, public records part of your complaint, and continue the meeting part in order to give the respondent
The
proper.
complaint will be moot, sir, if I might point out. The steering committee ends its meetings at the end of August. I want to access those meetings and attend the meetings. My request will be moot as to that issue if you separate it.
Chair Nee.
Member Cawthon?
I just wanted to. I'm reading over the first paragraph of Mr. Laurente's memorandum, and he does say that Ms. Grogan asked that members of the public be allowed to attend a meeting with the steering committee and the strategies group. And then at the end, she says the last sentence that begins on page 3, about in the middle. The answer was that the public could not attend because the committee was a passive meeting body, would be discussing confidential matters. Even in the way Mr. Laurenti did lay this out, she did ask to go to the meeting, and she was told that it was a passive meeting body. She was incorrectly told that because it was a passive meeting body, she couldn't come, where in fact a passive meeting body has to, on request, permit the public to attend. So I think we're safe in ruling on both matters. And since there is
let me just say this.
This is time sensitive. I would be inclined to see a violation.
Mr. Laurenti?
I think that First Staff Lieutenant Riley pointed it out, and I did address it, and it was brought up at the complaint committee, and that was that whether this, on page 120, this complaint form, whether or not that adequately reflected the intention of the complainant. It says public meeting violation, no. And obviously, from what we've been provided, it actually should say yes. And that's what threw us off, because we didn't have a full understanding of that.
Member Neber?
I don't know. From the beginning of this, from the complaint committee and to here, I was always under the impression it was about both. I was not confused at all.
I have to agree that I felt it was both as well.
And in reading today's packet, I had the same thing. I was looking more about passive bodies and the law.
I have to say I was under the same impression that it was about both, particularly since it discusses the answer here, as to why the public could not attend.
So I think we should move ahead on both.
All right, there is I believe there is consensus to move ahead with both parts of the complaint. Then, is there further? Okay, we've had public comment. We've had the rebuttals and the conclusions. So it's back with the committee. Is there any further discussion or a motion?
I move that we find a violation of 67.21 for failure to produce documents, and I forget what is the violation for refusal to permit attendance at a meeting, whatever that section is.
Under passive meeting bodies.
Refusal to attend a passive meeting of 67.3, is it?
No, 67.4 is the requirements of passive meeting bodies, and then 67.6E is about agendas and material for passive
While we
meeting
look
bodies.
for the number, I will second the motion.
Okay.
7.4.
Lieutenant, could you approach the microphone again, please? Why was the complainant denied access to the meeting?
I can't answer that, sir.
Okay, thank you. Yeah, I mean, it seems to me that to say that you can't attend because we will or might be discussing confidential or sensitive matters, I don't think there is blanket authority to deny access to a meeting like that. There has to be on the agenda a description of the, even if matters are to be discussed behind closed doors. You don't have, since you profess no knowledge of this, you don't have to respond if you don't wish. If you wish to be seated, you may. It says sensitive matters such as personal bias, employee relations, and legal opinions that should not be made public. First of all, I don't see sensitive, blanket statements like that as acceptable for denial to a public meeting. If there is a specific item, say a personnel matter, contractual discussions, labor negotiations, legal advice, even then, the specific matters that are going to be discussed behind closed doors must be listed. And to say that, well, we're going to discuss these things without really telling us what they are, that doesn't pass legal muster with me. Also, if they are going to be discussed behind closed doors, there may also, it does not say that these are the only matters to be discussed at the meeting. There may be other things on the agenda that are under law to be discussed in public. And if, in fact, all of the items to be discussed in the passive meeting are to be done behind closed doors, then the public should still have the right to attend the opening of that meeting and to be asked to leave once the closed door matters are to be discussed. So, to me, there is to me this indicates a violation. Sir, Lieutenant.
If I may, Mr. Chairman, I'd just like to indicate that that discussion, wherein Ms. Grogan was denied access to the meeting, apparently did not take place with an agent of the Police Commission.
Right.
For the record. Thank you.
Okay, thank you. Do you know with whom it did take place?
Yes, I do.
Ms. Grogan?
I asked Ms. Craven, the Boston director of the Boston Research Study, for permission to attend the steering committee meetings. She called me back and said, I have spoken with Peg Stevens, the city controller, and she informs me that you may not. And I asked her why and received the information that she gave me. This is a passive committee. You may not attend it. We are discussing private legal matters and confidential employee matters.
Okay, was Ms. Grogan speaking,
Was Ms. Craven?
Ms. Craven speaking as controller or as a member of, as representing the police commission, or whom was she representing here?
The city controller who sits on the steering committee. She's one of the 5 members of the steering committee.
Mm-hmm. And the steering committee was created by the police commission?
Yes. By the police commission and the San Francisco Police Department and the Boston researchers in concert, to the best of my understanding.
Okay, thank you.
I assumed the controller was authoritative.
Okay. This is very Byzantine.
Yeah, it's kind of... That can apply to both police forces at some point.
May I ask what motions are on the table right now?
Mr. Rustin, could you repeat the motions, please?
Mr. Chair, Member Cawthon has suggested a violation of 67.21 and a 67.4.
I would like to separate those because I don't. 6721 is a little bit more in depth. I would rather it be 67.6E, because if this is a passive body, I mean, at the basis, she requested the agendas for this, and it says that you have to get agendas if you put in 72 hours notice or whatever, what's going to be happening. 6721 is blanket, and I understand that, anything that they're discussing there, but I think more to the point is an agenda of what they're discussing, and I think that is more to what her complaint is. But
Okay, so you move for separation.
yeah, and adding 67.6E.
Okay, and which item would you like separated out?
I would like to separate 6721.
Okay. So let's take, we'll take 6721 second, and 67.6E you said, and what were the other?
I agree with 67.4 in her original motion.
67.6E.
Yes, that's what I'd like to add, and I'd like to separate out from her original motion 6721. Or whatever, I don't know what sub number it was.
Okay, without objection? Okay, the matters are separated. Let us take first 67.4 and 67.6E. Do we have a motion on those violations?
I moved to amend my.
They were moved and seconded.
Whatever.
Okay.
She moved, I seconded.
Is there further discussion on 67.4 and 67.6E? Roll call, please.
On the motion, Member Craven Green. Member Craven Green excused. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Just to be clear, what motion is this?
This is for 67.4 and 67.6E.
Okay. Aye.
Member Knebber, aye. Member Johnson. Member Johnson excused. Member Chan. Member Chan recused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
Aye.
Member Williams, aye. Member Chu. Member Chu absent. Member Nee.
Aye.
Mr. Chu, we have 6 ayes. On the second motion, which is 67.21, Member Craven Green. Member Craven Green excused. Member Cawthon. Aye. Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
No.
Member Knebber, no. No. Member Johnson. Member Johnson excused. Member Chan. Member Chan recused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
No.
Member Williams, no. Member Chu. Member Chu absent. Member Nee.
67.21 is general request for public documents. No.
Mr. Chair, we have 3 ayes and 3 noes. The motion fails.
Now, 67.4 and 67.6E has to do with the meetings portion.
Well, it has to do with it, if it is a passive meeting, the way you run it and what should be available to the public.
Okay, and we have found in favor of the complainant on that. Motion to find violation on the documents part has been defeated. Now, are there further? There are further meetings of the steering committee that are scheduled.
Mr. Chairman, if you're asking me as Commission Secretary to respond to that, I cannot, sir. I have no knowledge of the activities of the steering committee.
Okay. Ms. Grogan?
Can the task force give me any guidance about to whom to turn to find out when the next steering committee meets?
Mr. Laurenti?
I think you go back to the person that you were speaking to, the one who called
the research director.
The research director,
Yes.
to let them know what this body has found and see, what the next step would be for them. They have to respond to this.
We can issue, I believe we should issue an order of determination.
Yes.
That will direct the research director.
Well, I think it basically is directed to the parties who are tied in, which is the police commission. But because we have found a relationship, possibly a derivative relationship between the police commission, the contractor, I think that's how they're tied in, and so they cannot ignore it.
Okay. And the order of determination will be drafted by...
We'll work on it. Usually, Chris will do a draft. I will review it. It looks like I said, based on some communications that we've been presented today, that the Teresa Sparks has taken some ownership in this endeavor. So
Okay.
So we will work on that.
Okay. And how soon do you expect to have the draft completed?
Hopefully by next week, because I will not be available the second week of August.
The reason I asked is it does go out over my signature.
Yes.
And so
yes. We will work on that.
The sooner the better.
Yes.
Yeah. Thank you very much.
How do I obtain a copy of it, please?
Oh yes, all
Copy
parties will be given the orders of determination.
Copies are sent to complainant and respondent.
And may I have your advice? Is it appropriate to call the research director and give her the verbal response
Certainly.
at the meeting today?
Yes,
And
you have every right to do that.
Thank you. Thank you very much.
Thank all of the parties for attending. We appreciate your time to be here. Mr. Clerk, would you read the next item, please?
Item number 10 is the determination of jurisdiction on complaint filed by Dominic Mayonchi against the Department of Recreation and Park for allegedly withholding information.
Okay, as the complainant is here, is the respondent here?
I move that we find violation.
I second.
The jurisdiction.
I second on the jurisdiction part, but not the first part.
All right, we are judicious here about due process.
I gotta cut to the chase.
Okay. Motion to find jurisdiction. Roll call, please.
On the motion, Member Craven Green. Member Craven Green, excuse. Member Nee.
Aye.
Member Nee, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Caneva.
Aye.
Member Caneva, aye. Member Johnson. Member Johnson, excuse. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
On jurisdiction.
Member Williams, aye. Member Chu absent. Mr. Chair, there are 7 ayes.
Thank you. The complainant will approach the microphone, please. Thank you for coming. You have 5 minutes.
Thank you. Can I pass these out?
Certainly.
And I think I have enough copies for everybody. And I'll give I don't have a copy for Ms. Gong, but I will give her my copy as soon as I'm done.
Thanks.
Okay. Can I start now?
Please.
Okay. What I've asked the Department of to provide me is copies of the contracts that they have entered into with the marina berth holders. Now, the procedure is when you rent a slip there, you are given a contract, which it says here that I attached, but I have neglected to photocopy that. So hopefully Ms. Gong will stipulate that there is such a contract in existence. And before she actually sent me the documents, I asked her if she would be redacting any information on that document, and she said she would be redacting the addresses they put on the document. And that's when I told her that I did not believe that was proper, because there would be no way for me to contact the people who have contracted with the city if I thought there was if I thought that the contract would, in my opinion, was illegal. So that's when I filed the complaint to your task force. And in my opinion, there are certain addresses in certain circumstances are specifically not allowed to be disclosed. However, there is no specific exemption for addresses of people who contract with the city. On the contrary, section 67.24 says there is a presumed enhanced right of public access for contracts between departments and persons. In addition, one of the reasons they cited for it was the Constitution, California Constitution, which in the first Section 1 cites privacy. However, if you read Section 3B1 of the California Constitution, I don't believe that privacy applies to this situation specifically as to an address, a mailing address that is put on a contract. If you read the rest of the Constitution, it says that it provides people with the right of access to information concerning the conduct of the people's business. This is the people's business, and that's why I think the contracts should be provided without redactions. Now, I may mention that they were never actually sent to me because I told her, instead of ruining all the contracts, let's wait till we get this resolved, and we've done this very peacefully. Let's wait till we get this resolved. Otherwise, we're going to have to throw away all this paper and redo it. So I just wanted to find out from the task force whether they acted properly. I'm sure they were acting in good faith. I just think they were mistaken, and I think that the addresses should be provided to me. I am doing my own investigation into the activities of the harbor. I am a berth holder there. I myself have signed one of these contracts, and the information I found, I would like to share with the rest of the berth holders down at the marina. And that's, even though I'm not required to tell you why I'm doing this, I thought that would be some additional information. And I think that's the only issue here is whether whether the department should redact the addresses that were on those contracts.
Thank you. Is there anybody here to present facts and evidence in support of the complainant? Seeing none, would the respondent approach, please? Thank you for coming. You have 5 minutes.
Thank you. Hi, my name's Olive Gong, and I'm here for the Recreation and Park Department. I'm here for the Recreation and Park Department. And yes, it seems like, we agreed to give Mr. Minucci the documents, but we need to redact the personal information such as home addresses, email addresses, before giving it to him. And that's the only question here, I think.
Thank you.
Okay.
Is there anybody here to present facts and evidence in support of the respondent? Seeing none, committee?
I have a question for the respondent. On whose authority did you decide to redact the?
Well, I looked at the Sunshine Ordinance and, stated under there is that there are things that are considered personal information, that you can redact, which is personal information such as home addresses. But also, I asked my lawyer, Virginia, and she agreed. And also, Mr. Minucci suggested that I contact Frank Darby of your task force, and we did that, and he emailed us a response that says, Ms. Gong, as we discussed below are the legal statutes that recognizes the right to personal privacy, and then he listed the 4 statutes, and we had given your task force this information.
Thanks.
Can you, Ms. Gong, point to the specific provision in Sunshine that allows for that redaction?
I don't have it with me. I just know I read it in there that there is one that says that you can redact due to personal, privacy issues.
Okay, thank you.
Yeah.
I believe it's 67.1G.
67.1G?
Yeah. I'll get to that.
I have a question.
Member Knebber?
Mr. Laurenti.
Yes.
A contract such as a berth at a marina or, say, something else, does that hold up the same legal rights as a contract with the city for commercial or any other thing? Is there any legal distinction between that type of contract?
I don't see a distinction.
Okay.
I've seen case authority dealing with parties that may want to bring complaints or ask for redress, and for those issues, there has been some privacy interests that are implicated in that. But when you deal with an arrangement, a contractual relationship with the city, it's my opinion that absent some fear of some kind of retaliation or some type of adverse effect to disclosing it, that when you deal with the city and you form a contract and you, I don't see the privacy interests that weigh heavily in not disclosing it, at least not here.
Ms. Gong, could you approach the microphone, please? Did you seek any kind of advice from the contractees, the people with whom the city holds the contracts, the people holding the slip contracts? Did you ask any of them?
The yacht harbor masters?
No. I'm talking about the slip holders themselves, the people who have rented or leased the slips.
Oh, you mean did I ask them if they would mind if we release their information?
Yes.
No, I didn't do
Okay.
that. Yeah.
Please be seated. Thank you.
I had one quick question, Ms. Gong. Was the redacted information their home addresses or their slip addresses?
Their home addresses, yeah.
Would you have given him their slip addresses?
We didn't ask to redact that. No.
Sorry?
We did not ask to redact that. No.
So if he has the slip address, Mr. Manichi, could you come up for a second? If you had the slip addresses, you could still contact these people, right?
The slip address, I'm sorry, but the slip address...
Microphone, please.
The slip address merely tells you the number where the boat is at.
There's no mailing there?
There's no method of mailing.
Is there a harbor
to
master general mailbox?
No.
Is there any way you could deliver these things by hand?
No.
Well, I guess they could be delivered by hand.
No,
but
you couldn't, because you have to have a key to get into the slip.
But he has a slip.
Well, technically, they have 2 or 3 different keys. I can get into about a third of the slips. The other, but the reality is, if I asked the harbor master, he probably would let me borrow a key to go to the other ones if I wanted to go and deliver 600 pieces of mail.
Would or would not?
He probably would allow me access to the other berths, of which I do not have a key.
Is it 600? How many do you have a key to?
I probably have a key to, I'm guessing, 200, a third of them.
So if you got to 200, would that be of any help? If you got just the slip addresses?
No, I think this is valuable information for all the slip holders of the marina. And, and I have tried other means. The harbor master sends out a letter bi-monthly, and I asked if I could be included in the letter, so, to include a website or something so that people could find out the information I've gathered, and he refused that. So, I have tried other ways of contacting these people, and this isn't part of my second period.
No.
Because I just like to mention, well, I'll hold this.
Yeah. Thank you. Okay. Any further questions from the committee? Okay. Is there public comment on this item?
Hi, Kimo Crossman. A couple things. First of all, the email address should not have been redacted no matter what. Email addresses are never redactable under both the state law or under local law. It's never listed as a redactable item. So for sure, email address should be provided. And you found that as well in your own records when I've disputed it. Frank Darby disagrees with it, but you have found otherwise. And when people choose to become public officials, they lose a certain level of privacy. When people choose to do business, they become a more public person. Now, if the people were concerned about having that information, that contact information, I call it contact information because that's what it is. If they wanted to have that contact information not related to their home address, they're welcome to give a P.O. box or a work address. If they've waived that privilege in the same way that someone puts an address on the return corner of an envelope or on their stationery. If you choose to give that information on a contract, which I think most people would anticipate a contract being a public record, then you've voluntarily disclosed that information. And again, unless the city has proof that there's harassment going on, I don't think there's any justification for withholding even the mailing information. And that's what it is, mailing information and email address information.
Thank you. Is there further public comment?
Yes, Peter Warfield. I think there's an unfortunate kind of mania about the terrible things that might happen to people if, God forbid, somebody might be able to get in touch with them, which is tapped into by folks who, for one reason or another, decide they don't want to release that information. There are plenty of ways that people can ask somebody, please don't contact me again, and if there's a real legal issue, there are laws about harassing people and so on and so forth. None of that, in any event, is related to the specifics of the law, as I understand it. Now, I'm not connected to this case and so on, but Section 67.24 says on I, halfway approximately through, I'll read exactly, all withholdings of documents or information must be based on an express provision of this ordinance providing for withholding of the specific type of information in question, or on an express and specific exemption provided by California Public Records Act that is not forbidden by this ordinance. And then it goes on with Section 67.26, withholding kept to a minimum. It requires no record shall be held in its entirety, and it goes on and says, and keyed by footnote or other clear reference to the appropriate justification for withholding required by Section 67.27 of this article. This work shall be done personally by the attorney or the staff member conducting the exemption review. I heard the respondent say that she didn't have a particular reference to anything, and I certainly didn't hear that it was provided to the claimant. And it goes on in that section that I cited, the work of responding to a public records request and preparing documents for disclosure shall be considered part of the regular work duties of any city employee. Now, under Section 67.27 justification, let's read the first sentence. Any withholding of information shall be justified in writing as follows, colon. And then there's A, B, C, and D. And so I'll read those to you too since I have 3 minutes. Basically, it says every withholding has to be justified in writing, and I don't see that that was done here with specific references as required to the specific laws. And the writing as follows, for example, A withholding under a specific permissive exemption of the California Public Records Act or elsewhere, which permissive exemption is not forbidden to be asserted by this ordinance, shall cite that authority. B, a withholding on the basis that disclosure is prohibited by law shall cite the specific statutory authority in the Public Records Act or elsewhere. C, a withholding on the basis of that the disclosure will incur civil or criminal liability shall cite the specific statutory or case law or any other public agency's litigation experience supporting that position. And finally, D, when a record being requested contains information most of which exempt from a disclosure, the custodian shall inform the requester of the nature and extent of the non-exempt information and suggest alternative sources for the information requested if available. There is apparently no justification, nor was any provided as required, and I think that I don't hear that there's been any legally required explanations or justifications or documentation provided. Thank you.
Thank you. Further public comment? Public comment is closed. At this time, the respondent will have up to 3 minutes to present any concluding remarks, rebuttals. Does the respondent have anything further?
I just had kept, let's see, just a record of all our emails back and forth with Mr. Dominucci and myself regarding this question, and I had thought it was sufficient to send him Frank Darby's list of legal statutes that recognizes the right to privacy. That's all.
Okay, thank you. Complainant, you have up to 3 minutes.
You know, I do, excuse me, for the commission, for your own housekeeping, I don't like, I noticed that Frank Darby, who works for your department, provided the reason why I shouldn't get the information. And, I'm glad she brought that up because I don't think he should be the one providing a laundry list of generalities in order to prevent me from getting information. The only one other thing I think is important for you to think about when you deliberate on this is that there is no specific authority preventing that information from being given out, even though in some circumstances the legislature in the state has decided that home addresses cannot be given out, and they do state them. And that's why I listed that at the very beginning. There are certain sections that say you can't have a home address of a crime victim. It doesn't say you can't have a home address of somebody who contracts with the city. I mean, if they didn't want if they never wanted home addresses to be given out, they would have stated it. Now, there's also one quick example, and then I'll sit down. The motor vehicle, it's really interesting that the DMV records are exempt, including home addresses. However, there is a way of getting those. And then if you read Cal Health and Safety Code 18081, it says that if people did not want their home address given out, they could put a different address down. And I think somebody else mentioned that. You can put a P.O. box, a business address. All I need is contact information. This is not stalking information. It's contact information. When I find a violation, I'd like to inform people that, in my opinion, there's a violation, and they can do with that information as they please. And I think people could, if somebody did not want me to contact them further, that's all they would have to tell me. And perhaps a phone number would be, I don't need a phone number. I just need some some contact addresses. I do not know whether those are home or business or P.O. boxes because I haven't seen them. And to me, it doesn't matter what type of address it is. I just need to be able to contact, to send a general letter out informing people of their rights.
Okay. Thank you. Okay. Would the respondent please approach the microphone? You said you contacted Mr. Darby, who was helpful to you. Did you contact the city attorney's office? Did you contact your own counsel?
Yes, I actually was in contact with Virginia
Elizondo.
Dario Elizondo, and we have been in constant contact regarding these.
Did she advise you to redact the contact information?
Yeah, she said that personal information should be redacted, and she also looked at this letter that I had sent to your committee, and she said it was fine. And she has. We've been in constant contact about this.
Thank you.
So I'm a little surprised.
Thank you.
It wasn't sufficient.
Member Kneber.
Mr. Mayonchi, can I ask you a question, please? So I just want to clarify. You said that you were just trying to save paper. You requested, and she said that she was going to redact some part of it, and that's exactly what you wanted. So you said, don't give it to me, and we'll settle it further.
Okay, exactly.
That's what I want. Thank you. In light of that, I don't think it's a bad thing, but for me, it is. I think that excludes 6726 because they're not. She wasn't trying to exclude entirely. She gave a reason why she was excluding under advice of her attorney. So for me, I would move to find violation on 6727, just pertaining to the reasons why they're redacting and that they're not correct.
Okay, I'll second that.
Would the second and the maker accept a friendly amendment to add 6724I?
Right of access.
Yes.
Yes.
I would accept, yes.
Second and the maker both agree? Okay. Further discussion? Roll call, please.
On the motion, Member Craven Green. Member Craven Green excused. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Kneber.
Aye.
Member Kneber, aye. Member Johnson. Member Johnson excused. Member Chan. Aye. Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, aye. Member Chu absent. Member Nee.
Aye.
Member Nee, aye. Mr. Chair, we have 7 ayes.
Thank you.
It's 67.27 and 67.24 aye.
Okay. Ms. Gong, you will receive a letter shortly. This will be copied to the complainant. This will direct you to this letter will repeat the order of determination, and you will be directed at that time to provide the information unredacted. What you do with that order of determination will be up to you. If you don't do it, it may come back to the full task force with a recommendation for referral to the Ethics Commission. It'll be up to you to consult with your counsel and get the best advice as to how you should proceed from there.
All right. So
Okay.
you would like us to leave the documents unredacted?
That's correct.
Oh, okay.
You will receive an order of determination directing you to resend the documents with no redactions.
All right.
Okay.
All right. Thank you.
Thank you. Thank you both for your time. Mr. Clerk, could you read the next item, please?
Item 12 is the determination of jurisdiction on complaint filed by Brian Tomina against the Department of Building Inspection for allegedly not responding in a timely fashion to an immediate disclosure request.
Okay. Is there a motion to accept jurisdiction?
I so move.
Second.
Moved and seconded. Is there public discussion? Is there discussion among the committee? Okay. Roll call, please.
On jurisdiction, Member Craven Green. Member Craven Green excused. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson. Member Johnson excused. Member Chan. Member Chan excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
Aye.
Member Williams, aye. Member Nee.
Aye.
Mr. Chair, we have 6 ayes.
Okay. Is the complainant here? Complainant is not here. Is the respondent here? Okay. Okay. Is there, Mr. Strawn, please sit for the moment. Is there anybody here? Mr. Rustum, have you been in contact with the complainant?
As I said before, I sent the complainant 2 reminders.
Okay, and has he
hasn't
indicated?
responded.
Okay. Then I would, my inclination would be to move forward this. And let's start by asking, in the complainant's absence, is there anybody here to present facts and evidence in behalf of the complainant? Seeing none, would the respondent approach, please? Thank you for coming. Thank you for waiting through all this. So you have 5 minutes.
Thank you very much, Mr. Chairman. I'm just here representing the Department of Building Inspection. We did send a rather detailed response when this matter alleging lack of timeliness in terms of our response by Mr. Tomino was filed. I believe you probably read that. The letter stated very specifically that the initial contact was from Mr. Tomino requesting records was by fax with an erroneous phone number and no way to contact him to indicate in order to obtain the records he was requesting would take longer than 1 business day, as is typical for an immediate disclosure request. He finally called back into the department 2 days later. I explained that the phone number he had given us was a non-functioning number. He apologized, said he would send me an email. He waited 2 more days to send me an email. I then, by that time, knew from Mr. Kwong, who is with me today, that it was going to take some time to come up with all of the documentation he had requested. It was a voluminous request, and that we would act on it as quickly as we could. All of his email contact with me was extremely polite. He indicated no problem with how quickly or responsive the department was being. And then suddenly I get from Mr. Rustum the indication that he's filed a complaint for a lack of timeliness, and frankly, I don't think there's any merit to it, which is why I sent the letter on July 2nd and asked that the task force dismiss this as being without merit. And that's where we are today.
Thank you. Is there anybody here to present facts and evidence in support of the respondent? Seeing none, committee? I have one question. Mr. Strawn? Usually on faxes at the top of the sheet there will be a phone number on each page, a fax number. Do you recall if the fax that you received had such a number? From the
I don't. I probably have that document someplace, but I don't know how quickly I could find it. But I know there was no way for me to contact him based on looking at the document that I had. It appeared on my chair. It wasn't even faxed directly to me. It was faxed to the commission secretary for the Building Inspection Commission, and the secretary provided me a copy of it.
Okay, and the copy contained no number for the sender, no fax number for the sender?
Exactly. I had no way of contacting him.
Okay.
Which is why I used the phone number that he had included in the fax.
Right.
And when I dialed that number, and I actually had several members of my staff also dial that number, and there was a message saying that this is a non-working number.
Okay. Thanks very much.
Would that be on page 188? Top, you don't see an fax number.
Yep. It's blocked.
That's true. There is no fax number at the top of the... Okay. Okay.
But then, and then this, I'm sorry. Question for Mr. Strawn. And then this number that he gave, the 775-230-9370, was the number that was no good?
Non-functioning, exactly.
Okay, thanks.
Okay. Thank you very much. Further discussion from the committee?
I have a question, Mr. Strawn. So once you're able to be in contact with the complainant, you said that you started rolling out the documents. You didn't send them, weren't waiting until you had them all ready. In other words, you were sending him parts of the document, parts of the request.
No, I was informed by Mr. Kwong, who was going to be able to assemble all the documents since they were requests for documents connected to an RFP for a new technology system that the department has been going through a process to obtain, that we would provide the documents as soon as Mr. Kwong was able to produce them. And Mr. Kwong indicated to me it was going to take him 2 or 3 days in order to do that. It turned out there were 1,200 pages of documentation that we did provide to Mr. Tamina in response to that request. He has actually been back to us on at least 3 subsequent occasions, and we have also provided additional documentation to the degree that it was not duplicative of what he had earlier received.
And these were provided on a rolling basis?
No, they were provided on a stipulated basis. When I told him it was going to take, based on Mr. Kwong's estimate, it was going to take 3 days or 4 days or whatever it was going to take, I wrote back to Mr. Tamina and said it's going to take this amount of time and the documents will be ready to be picked up on such and such a date. And all of his email correspondence back to me was, thank you very much, I'll be there to pick it up.
Great.
Let me know the copying charges, and that was the extent of it.
Okay. Thank you very much. At this time, we will, even though I can't pronounce it, at this time we will take public comment. Seeing none, at this time, if the respondent wishes, he has 3 minutes to make any concluding remarks. Okay. Committee?
I'd just like to ask one question, Mr. Strong. You said that Mr. Tamina has asked you for additional requests since then.
Right.
Everything from his first request was given to him. The additional request was stuff that was not included in this, correct?
Right, and that he came back and asked for other information.
Okay. Thank you.
One question.
Member Kaufman.
But also, Mr. Strong, I had a question. You said the contract information would be to him by July 14th. Did he get the contract information he sought once the contracts were signed?
The contract has not yet been signed.
Oh.
And part of the information that he had requested, which we could not yet give to him, had to do with the fact that a contract has not yet been awarded. But he has not been back to me requesting additional information on that. I told him that in writing, and I haven't heard from him about that again.
So did you tell him that once they were awarded, you would provide him with the information?
I did. I made that very clear.
And you
that
will?
As soon as it, of course.
And did you make contact with him via email, since you said the phone number doesn't work?
Right. We've had subsequent emails, and he changed his phone number. I now have a phone number that does work as well.
Okay. Okay, thanks.
Okay. Further discussion? Is there a motion?
I move that we find no violation.
I second that.
Moved and seconded. Discussion. Roll call, please.
On the motion, Member Craven Green. Member Craven Green excused. Member Cotton.
Aye.
Member Cotton, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knepper.
Aye.
Member Knepper, aye. Member Johnson. Member Johnson excused. Member Chan. Member Chan excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, aye. Member Chu. Member Chu absent. Member Nee.
Aye.
Mr. Chair, we have 6 ayes.
Motion carries. Would you read the next item, please?
The next item is use of vendors or third parties to respond to public record requests by Brian Smith of the Planning Department. He is not, I don't see him in the audience.
Okay, in that case, without objection, this matter is continued.
No problem.
Speak to that.
Sir?
I'd like to speak to that for a second.
Okay, please do.
Kimo Crossman, this is the issue where Mr. Smith has been claiming that even though they have all-in-one copy, fax, scan machines in their office, that they, and also that they're scanning plans and storing them in a software application, that they want to charge the public for access to electronic records. And I would just say that I think it's contrary to 6721 that talks about making records, electronic records, available at the lowest cost and most accessible. And that's city policy. It's a mandate. And I would say that if he comes again, which maybe he's decided to think twice about it, but if he comes again, I would encourage you to counsel him on using his abilities to make records available at the least expense to people, to public, and zero if possible.
Thank you. Further public comment on item 14? Seeing none, item 14 is closed, is continued until our next regular meeting. Would you read the next item, please?
Item 15 is the approval of Know Your Rights brochure.
Okay.
Member Cawthon?
So I'm going to pass around the brochures. I did pass it around last time. The green brochures are the old form, and the blue brochures are the new. I hope everybody got
Point out the major differences.
That's my plan. What we did basically, wait till everybody gets one. So what we did basically is we reorganized it, we tweaked the language some, and we made some additions. You know, I think when the ordinance was first written, the focus was on public documents. And in one section here as to our hearing procedures, it focused only on public document violations. It didn't focus on public meeting violations, so we input the public meeting violations. As in 67.21E, I do hope the Then on page 2, we talk about our hearing procedures and how you file a complaint. Then we talk about what our responsibilities are down further on the page. And we go on to what we can't do. That was Mr. Johnson's suggestion. So we put in one of the things that people come here and hope that we can do when we in fact cannot. So we say we can't hear complaints that don't involve records production or the right to attend and comment at meetings, and also that we can't force a department to create a document. Then we get to the membership, and on the last page we talk about, again, about the outreach we do to the community and how we have translated this document into several languages. A little bit more information about what to do if you've got a violation, and if you'd like, and how to get a copy of the Sunshine Ordinance, which I think somebody today wanted. And then we put the history on page 6, and then we put the final contact information on page 6 at the end. So we did pass this out when we went to make a presentation to Shanti, and they seemed very happy. Shanti was the one that T.J. Lee brought before us. I think it was Mr. Pitts who had a complaint that they weren't doing something. They weren't providing public records, so they were very pleased with this, and we did a good presentation. So I hope that this is acceptable to the committee.
Thank you. Is this final? Because if it's not, I would have some tweaks to suggest.
Yeah, we made a couple of typo tweaks between this and the last time. This is version number 6, so we've been through a lot of drafts. But if somebody has a change, sure. I mean, we're happy to include it.
Let me suggest a couple in column 3.
Page 3.
Okay.
Well, on page 3, that's correct. Fourth item down, make referrals to a municipal. I would insert the words or state office, because that does include the California Attorney General.
Okay. So, Chris, are you getting this? Mr. Rustum?
Through the chair, yes.
You're getting poor Chris. He's going to have to do draft 7. Okay.
On page 4, under membership, rather than using the words submitted from or submitted by, I would suggest nominated by.
Okay.
And under the 4th item of that, New California Media is now New America Media.
Okay.
New America Media. That's what I have.
Okay. Anybody else?
Other.
This is just formatting, since you're going to be redoing other things. On the front page, the key sunshine provisions, that should just be neatened up so that the first 2 items are in line with the second 2.
Oh, I see. Okay.
Correct.
You go aye.
Okay.
Okay. Any other comments?
Okay.
Okay.
We'll fix it up.
Is there any public comment on this item?
If I may say my apologies, Peter Warfield. I haven't seen this in advance. I wish I had seen it in advance. But I do have a very few things to say. I think it would be useful if you did solicit the public by providing this in advance. Perhaps you have it in the agenda packet. Anyway, it wasn't what I came for, so... With respect to key sunshine provisions, I think it's important to say the public has the right to inspect and copy public documents. On the first page, under key sunshine provisions, the first bullet item, thank you. I think for free is extremely important. The public has the right to inspect for free and to obtain copies of public documents, or however you want to word it. The key issue there is that the people can inspect for free. The second thing is I don't see the promptness provision. There are many references in the Sunshine Ordinance to promptness, to no unnecessary delay. Sometimes there are time constraints. You have mentioned the time constraint in item 3, but I think that it's important to point out that the public has a right to inspect for free and to get a look at, as well as copies, promptly. And you can define those in any way you want. I would suggest also references to the statute here as you have them on, for example, page 3. And I think that would be very helpful to the public so that they can actually find the references, which appear to be mostly on page 3 and a tiny bit at the top of page 4, the references to specific citation of the section of the statute. I think that would be useful for every one of these paragraphs. The provision for immediate disclosure, I think, is a rather specialized matter, and it is a little bit arcane because there are requirements as to has to be on paper, has to have a certain format. So, for example, from memory, I'm saying that it has to have at the top that it's an immediate disclosure request. It has to have those exact words. I cannot call up somebody and say, gee, Mr. Rustum, I have an immediate disclosure request. It's not going to work under the law. So I think that would be useful to tell people, as well as where to find the details in the statute or even describe them right here. Has to be on paper, has to be delivered in such and such a way with the exact words at the top. So I think those would be my immediate suggestions, just from what I'm seeing here on a very, very quick view. Thank you.
Thank you. Further public comment?
Kimo Crossman, I want to say that I think this is great that you're doing outreach to the public about what Sunshine can do, and I think that's excellent. I do have some suggestions. And by the way, I agree. Everything Peter said I thought was excellent. One thing I would say would be there are other provisions that are useful to the public that, and I'll point them out here in a second, but I think that some of the items under task force responsibilities, under panel 2 and 3, some of them are fairly arcane, and I don't think that typically the public cares about whether they get an annual progress on the index of records. I mean, annual progress, by the way, that's not even relevant anymore. That was only supposed to happen until they got an index of records. So there's some task force responsibilities here, approving bylaws, so forth like that, that aren't really, no one cares about that, and definitely for the public who you're trying to communicate with, I think you could strike them and talk about some other things that are useful to the public. So like the 7th item down, approved bylaws, 8th item down here, report from city administrator about index of records. I would suggest that you, I like what Peter said about free. And there's definitely, I've been making a big push for getting free copies of electronic documents. And people, when I tell them, hey, ask for it scanned and have them email to you, people are like, wow, they can email to me for no charge. They're very happy and pleased to hear about that. And I would encourage that you make that clear in this document. Additionally, there's a whole section that talks about contracting provisions in here that are not outlined here at all, that are very useful. One of the big selling points that always comes about when you're talking about Sunshine to the public is why is Sunshine important, and one of the main reasons is, well, because you can monitor the contracts the city gets into and make sure that they're, good contracts. Sunshine has some extraordinary provisions regarding RFPs and contracts about access to information in real time, the negotiations in real time, and a 10-day waiting period before adoption of a contract, before it goes to the policy body. Those are all very unique and very important. And I would want to highlight that people can see real time what's happening with contract negotiations and then can weigh in 10 days before it's adopted. This last section, page number 4, says what we can't do. And then the next paragraph says the Sunshine can hear complaints about public records and or public meeting violations. So that's a little confusing. Why is it saying what we can't do, and then it just says what we can't do? And the last thing I would suggest is that you put a date on this so you know how current this brochure is.
Thank you. Further public comment?
I have something.
Seeing none.
My eagle eye found something.
Excuse me, Member Cawthon.
After the numbers at the bottom of each page, I would delete the periods.
Did you have something else, Member Cawthon?
I do. Well, let Ms.
Williams.
make hers first.
Microphone, please.
My neck
Microphone,
of the woods,
please. Member Williams.
Microphone.
Oh, I'm so sorry. My neck of woods, where I'm from, on page 2, it says the task force must notify the requester of the outcome of the hearing. That's good, but I think it should be put more in emphasis, as we've heard out here. If you find in violation, what's going to happen? What's going to be the outcome? I see how you said it in here. We're going to give it to the ethics. What is the ethics going to do? I mean, people don't understand that. They don't. Some of them don't even know what the ethics committee is. You know, they don't know what ethics is. They know what the board of supervisors of the board of supervisors is, but after you find in favor of me, what's going to be the outcome? If you don't find it, what's the outcome? Is going to be a penalty? What are you going to do to these people? I mean, what's happened, you know?
Okay.
And I think it should be put as strong. It's against the law. It's illegal to, I mean, you know, I like the word, it's illegal to withhold information for people. They have the right. So I think that the word illegal should be in there some kind of way. People have the right to know, and that's what happens to people that don't read. They really don't, and we're talking to out in the southeast side. They don't even know that they have the right to come down here. And then the ones that come down here, but what they gonna do after they find in violation for us? We never make that clear. We might be sending them a letter, but then it never gets really to the point of where they're satisfied.
Okay, thank you. Yeah, the first paragraph talks about what the rights are. I mean, you know, I'm like Woody Allen. Every time I read something I've written, even if I wrote it 10 years ago, I'm always editing it. But I will definitely take these ideas, and we will put, Mr. Rustum, could you put brochure back on the agenda for the EOTC committee? We meet the second Tuesday at 4 p.m., so if anybody wants to come and work with us on this, it's fine. And I'll bring up all these items that I did make the changes that
and it looks
I made the word changes that people suggested, and I will discuss these other matters at the meeting.
Through the chair, it's the second Thursday.
The second Thursday, is it? Okay. I usually get there, so I must know. Okay.
I guess procedurally, will this be accepted subject to some further amendments, or
Bring
is
it
this
back
going to...
we can bring it back in August
Bring it on
if you like.
Till we get it like we need to get it.
Right.
It's not us that needs to understand. It's the people out there that need to understand.
Right.
So we're not going to approve or disapprove of it. We're going to continue it.
The agenda says possible action, and possible is the operative word here. If there's no motion, we can just send it back to the EOT committee.
I see. Okay.
It's we're going to make a presentation to the Coalition for SF Neighborhoods on August 22nd. So I would ask that we be permitted to hand this out. I mean, we can make the changes that we can make the changes that the verbal changes that people made. I'm not, and depending on how things go at our meeting, but we won't be able to come back to you until the fourth Tuesday. So my suggestion would be that this is a really useful document, even the way it is, and we can certainly insert the language changes, but I would like to be able to pass it out because it certainly says what everybody wants us to say. There are some things that we could add to make it stronger, but we also have to be concerned about space limitations and format.
But Sue, when we get into there and start talking to people anyway, we kind of put it in our own lingo anyway. You know, whatever audience, we can tell the feeling if they're grasping. Like you say, deliberation. Some people might not even say deliberations. We might say your complaints or something. Whoever we before, you know,
Sure.
we can kind of, So this is good. We can pass it up, and
Right.
you're gonna put it in. We're gonna put it in our own words to make it, comfortable.
I tried to make the language really, really simple.
Yeah.
But
Okay,
deliberations, I'll have to think of of a synonym.
Okay.
Yeah, wonderful.
And I believe we're ready for the next item. That would be the complaint committee report.
Yes, members, the record that's in your packet is an accurate reflection of our meeting. I have nothing to add. That concludes my report.
Okay, thank you. Item 17 is the report of the Compliance and Amendments Committee. The minutes tell you pretty much what you need to know. I would just call your attention to the fact that the amendments package and the electronic records policy formulation are still works in progress. Mr. Clerk, could you call the next item, please?
The next item is the report from the Education, Outreach, and Training Committee.
Okay, I've got a few things. We had Mr. Zex before us with the, what was that group? Was the
Office of Economic Development.
Mayor's Office of Economic and Workforce Development. And he did get the documents he requested. He used them as the basis for a second request, and he's working with Ms. Pamela. And so we decided not to bring this. Since he's getting what he wants, he didn't want this to go further. On outreach, we're going to make a presentation to the Mayor's Office of Workforce and Economic and Workforce Development. The Glen Park Association has shown interest. We're going to go to possibly Police Community Relations and Council of District Merchants. If anybody else has any other ideas, I'm hoping Ms. Washburn's going to give me the name of a contact of League of Women Voters so we can pitch them. Also on our agenda, and I did mention that we went to Shanti last month. We had on the agenda the planning department's requirement, or at least a requirement in a document that I saw, that document requesters make an appointment. We have asked them to come before us. We asked them to come to our July meeting, but they weren't able to. We've asked them to come in August, and we simply want to discuss with them that we feel it's important for someone to tell you when they're going to come in, but that it's not appropriate, nor is it legal to require an appointment. And I think that was put into the original ordinance so that people wouldn't stall you by saying you can't come in until you have an appointment, and we can't make an appointment with you today. We also are working on the PUC's sunshine procedures. They have a long procedure which they gave to us. That was the case of Mr. Joseph Singh presented the PUC case, and it was filed by Steve Lawrence. So we're going over their procedures, and we're finding quite a few things that need changes, and so we're making the changes. And the final thing is that Mr. Johnson suggested that we have a social event and invite anybody who wants to come, and that would be a good way to do outreach, and it might be some fun. And I talked to Chair Nee about it, and he said he was going to talk to Mr. Laurenti about the ramifications. Well, that concludes my report.
Thank
Okay.
Member Williams.
I just want to say to the membership that I called, I didn't get any notification. I don't know, maybe it was because of the condition that I was in or whatever happened. I didn't even know that Member Nee was elected the chairperson, and he had asked, and when I got the plans for the committee, my name was taken off because it was, and I have talked to him about it. I do not wish to be taken off because of the two tragedy of
Okay,
loss
Member
of
Williams,
my
I was going to discuss that
Yeah,
toward the
yeah,
end of
but
at the end of the
I just want to
meeting.
thank the members that did call me and and kept me up in their thoughts. I want to thank you very much for that. But it's been a difficult year for me, but I'm getting back on track. So, Sue, I just want you to know that I'll be back.
Ms. Williams is always a very dedicated, zealous, and loyal member.
Okay. We will discuss this toward the end of tonight's meeting. Is there any comment on the on the Education Outreach and Training Committee report. Public comment.
Kimo Crossman, I want to speak about the SFPUC sunshine procedures. I'm concerned that they're advocating for a central person to receive sunshine requests. The ordinance is very clear, as well as even state law, that you can submit a request for information to anybody. And there's been this ongoing theme where departments say, well, we want to have one person get the request. And the explanation is, well, we don't want to lose it, misplace it. But another way of looking at it is that it's a way of message control and so forth. I'm concerned that SAPUC is advocating pretty strongly. They're saying, I can't take the request. You have to send it to someone else. Don't give it to me. That's just, not acceptable behavior. And I'm uncomfortable with SAPUC advocating for that. And I'm even uncomfortable that somehow slipped into the draft Sunshine Ordinance where there's some sort of custodian of records that's only one person rather than anyone who happens to be a city employee. And I'm concerned about that, and there's going to be a major uproar about that if that stays in the draft ordinance.
Thank you. Further public comment?
Peter Warfield again. I'm not sure, without having the sunshine procedures of the SFPUC as part of the Education Outreach and Training Committee draft minutes, it's a little bit difficult to make sense of this. But there are some things that I think are key points. First of all, what the previous speaker said, the question of a custodian of records. Certainly we saw the library under Mike Hausch, who has now gone to the San Francisco Public Utilities Commission, work very hard to confuse people about what custodian of public records means so that people would think it was a single point of entry and requests that was required to be contacted for information requests, when in fact the Sunshine Ordinance is very clear that what Mr. Crossman said is exactly correct. Under 67.21a, every person having custody of any public record or public information, as defined herein, shall at normal times and during normal and reasonable hours of operation, without unreasonable delay and without requiring an appointment, permit the public record or any segregable portion of a record to be inspected and examined by any person, and shall furnish copies, and so on and so forth. This is crucially important. As a minor thing, I went with a fellow member of the Library Citizens Advisory Committee to a branch library where she was friendly with the librarian. It was a little before opening time on a Saturday. We were let in. We were shown this, that, and the other thing. This person was interested in very unsensitive circulation records. So the branch librarian showed us the monthly library circulation records, which shows all the circulation at each branch and the cumulative, so that in June, at the end of June, you would get the annual. So my colleague said, oh, could we have a copy? And all of a sudden, frost set in. And the branch librarian said, oh, I'm kind of uncomfortable about that. Could you maybe request this from the chief of branches? Well, excuse me, but the chief of branches ain't in on a Saturday morning, nor on an afternoon, nor on Sunday. And who is the chief of branches, and how do you get in touch? I mean, it made enormously complicated what was basically in her hand, that she could have made a single photocopy for her, from my colleague, and just given it to her. That's an example of the unnecessary obfuscation that happens when you have a single custodian of records through whom everything has to go. And In addition, through the custodian, you guarantee that very likely most requests will go through the person who's least knowledgeable about what the specifics are, rather than me asking somebody who knows what they're talking about. Paragraph 13, you should never have to ask in advance or notify anybody in advance. It may be a courtesy, it may be helpful, but Section 6721A says anybody can walk in at any time and say, I'd like to see such and such.
Thank you.
Thank you.
Okay. Further public comment? Okay, the chair wishes to apologize. I did not call for any public comment on the previous committee report, so if there's public comment on the report of the Complaint Committee or the Compliance and Amendments Committee, please approach.
Yeah, I did have a comment on the Compliance and Amendments Committee. I believe DTIS has submitted a letter to that committee regarding the cost of email retrieval. Is that accurate?
I believe so, yes.
Okay. So what I understand is that the IT department, the city's IT department, has was told by you to retrieve some emails that had been deleted, and they finally came up with an estimate. They said it would cost them $10,000 to retrieve the emails from backup, and so I did analysis on that issue, and based on the fact that under 6726, in which the responsibility is for all city employees to respond to public records requests, which is a provision, it says it's part of every city employee's job duties, and based on the fact that the only exception, the only portion of Sunshine that talks about programming, which is under 6721L, that talks about programming is only with regards to copyrighted programs and disclosing information that was copyrighted. I believe that programming is required if assuming programming is needed to retrieve those records, that should be done, and there should be no charge to it because it's part of every city employee's duty to recover records. Now, I'm not suggesting that new reports be created or new summaries. That's creation of a new record. But extracting the data in the first place should not be charged, because otherwise what you're allowing people to do is just take information that was previously disclosable, putting it into a computer, and now making it unaccessible. And I don't think that was ever the idea with computers. The idea of computers is to make information more accessible. And as we know, 6721, it talks about 6721-1. It talks about making information more accessible electronically. So I would encourage the task force, and I've sent an email about it, to find that there should be no charge to recover emails. And plus, I don't believe that programming is required to recover emails. It's to run a recover process and extract the data out. There should already be software tools for that. So I don't think any of that justification is valid.
Thank you. Is there further public comment on either the Compliance and Amendments Committee or the Complaint Committee report? Seeing none, public comment is closed. Could you read item 19, please?
Chair, can I ask one quick question? Is it New America or American Media?
America.
America.
No N at the end. Okay.
Item 19 is the administrator's report. Since Cheney is going to discuss the committees, I won't say anything.
Okay.
I'll wait for it. That
Okay.
concludes my report.
Okay. Is there any public comment on the administrator's report?
Members, I'd like to point your attention to a website called sfethics.org. That is a website that the Ethics Commission created that's separate from the city government website. It has the digital audio of all the meetings up there, and they're uploaded the next day. And it also has any communications sent to that body. Policy body communications are posted out there online, both of which this task force doesn't currently provide for. And I would encourage strongly that the task force consider emulating the good government transparency of ethics by directing the administrator to work with Department of Technology to create a similar website. Right now, I have to order CD copies of the recordings of the audio, and I would actually also encourage the task force to look into having the administrator actually. It's very easy at this point to make the meetings stream online live on the internet, so that if someone can't attend in real time, they can listen at home on their computer.
Thank you. Further public comment on the administrator's report?
Yes, Peter Warfield again. I appreciate and thank you for including a communications received log. It's on page 227 and follows the complaints log. And I would only ask that you try and perhaps give a little bit more than a single word or 2 words, which seems to be 2 words is the maximum. The 14th of June, James Chafee, from James Chafee, description coffin. Is that a phone call? Is that asking when is the item coming up? There's no indication, and I think it would be useful to give more information. The Board of Supervisors includes on every agenda that they put out a listing of communications received, and this goes on usually for 2, 3, 4, 5 pages, depending on how many they get. And they typically give 2 lines or even 3. That's a general, one might say, a summary of what the communication they have received is about. So they might say, Peter Warfield sent a letter concerning his opinion about the downsides of the Park Branch library planning process. And it's, I think, your guide for yourselves for this might also be just simply what the rules are for a reasonable agenda item, so that a normal, reasonable person of average intelligence can understand what the issue is about. Certainly I'm interested in what many of these people have to say, partly because of their names and partly because of the subjects. Kimo Crossman, ghostwriting. Bruce Wolf, ghostwriting. Gee, 2 people sent you or contacted you about ghostwriting. Wonder what's that about. Maybe if I saw what it's about, I would say I don't need to know more about that. I think it would be helpful for the public, as well as maybe save some wear and tear on your administrator, who wouldn't have to answer perhaps as many requests to explain what it is or see what it is, when it's easier for the public to recognize I'm not really interested in any of these except this one item right here, and I'll just ask Mr. Rustum if he could show me that one. So thank you for including this. I don't recall seeing this in prior ones, and I would urge you most heartily to let me know, what does my supervisor, what does newsletter mean? What was the concern or the issue that Ross Mercurini expressed on that item? Thanks very much.
Thank you. Is there further public comment on the administrator's report? Seeing none, public comment is closed. And that takes us to the final item, announcements, issues raised by members of the task force, etc., comments, questions, future agenda items. Okay, I do wish to discuss the matter of the committee appointments. Thank you. All of you should have received my proposals on the committee lineup. And I wish to address specifically education, outreach, and training. Unfortunately, before suggesting these committee memberships, I did not have any contact information for Member Williams. I would have liked to have talked with her, and that's why I put at the very top committee assignments I am proposing rather than locking in concrete. What I'd like to do is, on EOT, put off making a definitive decision, at least for the moment. There are still a couple of weeks before the EOT committee meets, second Thursday of the month, I believe. There are a couple of things coming up that I think can help us moving forward. Number one, as I noted, it's very possible that seat number 4 will be filled soon. That would give us some additional flexibility. Also, perhaps one of the other members of the of that committee would, in the meantime, be willing to step aside. I noticed that members Chan and Johnson are on multiple committees, so perhaps they would welcome the opportunity to step off of one of them. So I will contact them both and see if they would, if either of them would be willing to relinquish his seat in order that member Williams could remain on that committee. Mr. Laurenti, were you about to comment?
Oh, yes. I think that a bit of history regarding education outreach and training. We had a concern, at least, about being able to conduct business, and we had a problem for a couple of months of not having a quorum. That was one of the reasons why there was a request that the membership be expanded from 4 to 5, therefore being allowed to have more of an opportunity to have 3 members present to constitute a quorum rather than having 3 in order to constitute a quorum when there was 4. And that was I think that was the rationale for expanding it. I think if you're going to reduce it back to 3, which is totally fine and within discretion, it was just solely concerned about having at least 2 people show up for meetings so that business could be conducted, because there were at least 2 sessions where Lieutenant Mahoney showed up and there wasn't a quorum to be able to conduct formal business. And that was unfortunate that that happened twice.
Well, what we're facing here is that Member Washburn has asked not to serve any longer on the EOT committee, and that would mean we would have 4 members. And so then you have, a 3 out of 4 quorum situation. That can make things dicey. Member Cawthon?
I just wanted to say that we did discuss this because it was very difficult for us when we didn't have a quorum and we had Lieutenant Mahoney, and this happened twice. So we did have to have an informal gathering, and we took notes instead of minutes, but it would have been good if we had been able to take actions. We decided, should we try and reduce our numbers or expand them? We thought we would try and expand to 5 so that we could accommodate everybody who wanted to be on it. The problem is it's an awful lot harder to get 3 people than it is 2. And if anybody wanted to be on our committee, I would ask that they make a commitment to come to meetings. I can't speak for Member Chan and Member Johnson, but I do know that they have expressed a desire to continue doing the work we're doing. I know Mr. Johnson's got a couple of projects that he has started. So, it would be up to them whether I know that Mr. Johnson's on every single committee, and Mr. Chan is on 2. So maybe Mr. Nee and I could also discuss this before a definitive decision is made.
Okay. And, if and when seat number 4 is filled, perhaps we could re-expand to 5.
Sounds like a plan.
Okay. So, at the moment, we'll put off any definitive decisions on this and see where it takes us going forward. I wanted also to query Mr. Laurenti regarding the suggestion on some kind of a social reception thrown by a committee. It's one thing, I think, if we are invited to somebody else's reception, we all show up, and as long as we behave ourselves per the Brown Act and the Sunshine Ordinance, we're fine. But I'm just wondering what if any ramifications there are about a public body, about a policy body throwing a social function on its own.
I think that goes to the heart of the problem, where you have potentially a quorum of members of a policy body attending, even if it's under the title of being a social gathering. You have the problem that it could very well be a public meeting and therefore need to be noticed, etc. Just like the problem with having retreats, the title retreats. Well, we know that retreats are actually public meetings and have to be scheduled as such, and so you don't have retreats per se where you're removed from this setting and going to a park, or you're going to a club, or whatever. I think we need to look at it very carefully. That's the problem. I wish that we can have. The best that I've seen is that where we, during the course of a regular meeting, we take a break and have a social event where we honor somebody, we cut a cake, or we have pizza, we thank somebody for their appearance, we give them an award. People that are at the meeting come over and we share it. And I think that's what we've been able to do in the past. And I just have concerns about trying to schedule something off-site with more than six or more people of this task force.
I could just comment on that. I don't think Mr. Johnson's idea was to have a separate and distinct meeting. I think he intended to have something while we're having a regular meeting and invite the audience to participate with us, or maybe invite other people to come, so that it wouldn't have to be noticed. I know that we had a gathering when Donna Hall, our first administrator, left. And I believe that at one point we had something with Bruce Brugman, and pictures were taken of all of us. So, and I remember something we had in the back room for Doug Comstock, or I forget who it was, somebody's birthday, and we had food back there. So, I think it's doable without going to a huge amount of trouble. I don't like things that create a huge amount of trouble, and I wouldn't want to be responsible for it.
Member Williams.
Can we move the meeting adjourn, or?
Well,
she's not going anywhere. She's not going.
Well, as long as you're not in. I'm getting ready to give you my email. Okay, but as long as you're sitting out there, the meeting has to recess.
Oh, okay. I'll come right with you. Okay, wait a minute. Get myself together. Excuse me. I'm sorry.
Well, it's okay, procedure-wise.
Okay, thank you. Mr. Laurenti, did you have any further comment?
No.
Okay. Public comment on item number 21?
Hi, Kim Crossman. A couple things. One is, in general, the discussion about committee assignments and about social things, they should generally be agendized and not just thrown in at the end of a meeting if it's going to be a discussion. So I would caution the members about that. But nonetheless, Sunshine's makes complete, 67.3, 4B and C talk about just this issue of having social meetings, and they're totally okay. Attendance of a majority of members of public body, as long as they refrain from discussing items before the body. And then again here, attendance of majority of policy body that's purely social, recreational, or ceremonial occasion. So I don't think there's any problem with the members attending, as long as you just don't talk about sunshine matters. I'm not sure what the confusion is. I mean, it's pretty clearly provided for here. Now, you can't have a meeting before you can't have a meal before the meeting or after the meeting, but that's a different scenario. The other thing I want to say is I would, again, ask that the task force consider agendizing future items for job performance reviews of Mr. Rustum and Mr. Laurenti. That's done for every other policy body, and I think it's an appropriate use of the task force time to review the performance of the people that serve the body.
Thank you. Further public comment on item 21?
Yes, thank you. I too would caution about too extensive a discussion about specifics of such things as committee assignments and so on, when that seems to me to go a little bit beyond the discussion of future agenda items. There have at many times been comments made by your deputy city attorney, either because he has been asked by task force member or on his own. And I would urge you to codify in some way to document what those are and what exactly advice has been given and so on, because I think that this is a very powerful influence on your own concept of what's right and wrong, of how things should work and so on. And I think it develops in your minds procedures, processes, interpretations of law, and so on that you do use or may use in future public meetings and public actions. If they are not documented in some fashion, then I think you deprive yourselves of a record, especially for those, for example, who are not present. You certainly deprive the public of knowledge about those comments, opinions, decisions, and so on. I'm not sure how far I would take it, but certainly when there's a question of law or a question of an interpretation of law, I think that it's important to document it. I'm not saying it's wrong. I'm not saying there's any reason you should not ask your deputy city attorney. But what I am saying is that when, for example, your city attorney makes a statement of opinion about how the law works or should work, you internalize that, and then later a member of the public comes before you and may be baffled by what's happening between them and the task force, not realizing that there was something said at a previous meeting. Now, it's good, and I'm glad to see long minutes. It's good, I think, to summarize your own comments as much as you can, and I'm grateful for that. But I think that when your city attorney gives you an opinion, especially about law or the interpretation of law, it does carry an unusual weight that's different from your own deliberations amongst yourselves. And so I think as a public service, as well as for your own members who aren't there, and as a record, it would be very valuable just to make sure that these things are documented in some fashion, particularly in the minutes, possibly in minutes and separately somewhere else.
Thank you.
Thanks very much.
Mr. Laurenti, did you have a comment?
No, I don't have a comment.
Okay, thank you. The chair will note there is nobody else in the audience gallery, so public comment is closed. And I believe that takes us to the end of our meeting. Is there a motion for adjournment?
Second.